Greetings to everyone present at today's public hearing held by of the Prosecutor Vetting Commission. I am Virginia Moraro, Vice President, Vice Chair of the Prosecutor Vetting Commission and Chair of Panel B. The Prosecutor Vetting Commission was established and performs its duties in line with Law number 252, adopted by the Parliament of the Republic of Moldova in 2023 on the external evaluation of judges and prosecutors and amendments of certain regulatory acts. This law establishes expressly that the Prosecutor Vetting Commission shall carry out an evaluation of prosecutors' ethical and financial integrity mentioned in Article 3 of the law, mentioned in the law as subject of evaluation. The panel carrying out this hearing consists of 3 members and was established to evaluate subjects in line with provisions of Article 15 of Law 252 on the 5th of June 2024. Together with me, you can see my panel colleague, Mr. Cornel Lebedinsky, national member, and by Zoom video conference, we have Mr. Christopher Lehman connected, who is also the chairperson of the Prosecutor Vetting Commission and a member of the panel B for the evaluation of a subject that is before us today. Today's hearing takes place in line with Article 16 of the mentioned law and according to the Commission's rules of procedure approved under Law 252. The subject of today's evaluation is Mr. Eduard Varzar, prosecutor in the General Prosecutor's Office, subject of evaluation under Article 3, Paragraph 1, letter E, and Paragraph 3 of Law 252, in his prior capacity of prosecutor and Deputy Chief Prosecutor of the Anti-Corruption Prosecutor's Office. Greetings, Mr. Varzar. Welcome to today's hearing. Greetings. The hearing takes place in line with Article 16 of the law and in line with the Commission's rules of procedure approved for evaluations to be carried out under Law 252, both during the evaluation process and in today's hearing. The panel has been and is supported by members of the Secretariat. Today's hearing, similarly to all of the other ones, is held in public hearing, being accessible to the public and media. Also, to ensure accurate interpretation, as the hearing takes place with interpretation between Romanian and English, I would like to kindly ask all speakers to speak slowly and clearly to make sure that our interpreters could ensure a precise interpretation. Also, in line with Article 16, paragraphs 3 and 4 of Law 252, the hearing is audio and video recorded. In order to ensure the transparency of the prosecutor's evaluation process in line with the article mentioned before, the hearing is recorded and the recordings will be available on the Commission's official website within 3 days from today. At the end of this hearing, Mr. Varzar, you will be given the possibility to come up with a closing statement if you'd like to make one. I will start by briefly describing the evaluation process of subject Prosecutor Eduard Varzar. The Commission started the evaluation of the subject on 24th of May 2024 by notifying the prosecutor by email and requesting to fill out and submit to the Commission the declaration of assets and personal interests for the last 5 years, which includes a list of close persons that are working in the judiciary, in prosecution, or in public service, as well as a questionnaire on ethical integrity as provided for in Article 12, paragraphs 3 and 4 of Law 252. On the 6th of June 2024, Mr. Varzar requested to suspend the administrative procedure launched based on the hearing sent on the 24th of May 2024 to assess the subject under Article 3, Paragraph 3 of the law until a final court decision is issued on the legality of the decision of the Superior Council Prosecutor number 1-152/2024 of 21st of May 2024. On 12th of June 2024, the Commission informed the subject that the request to suspend the timeline for submitting documents as a result of the notification of starting the evaluation cannot be accepted. On the same day, he argued that the period offered by the Commission to submit documents, specifically 24th of May to 40th of June 2024, the subject was in a vacation, a longer period, as well as a business trip, which affected his possibility to fall within the established timeline. On the 13th of June 2024, the Commission informed the subject that it accepted the extension of a deadline until the 2nd of July 2024. Mr. Varzar submitted to the Commission the requested documents, filled out, signed, and with the appropriate annexes on the 2nd of July 2024. Also, in line with Article 12, Paragraph 5 of Law 252, by filing declarations and questionnaire mentioned above, the subject of evaluation declares on his own responsibility the accuracy and completeness of submitted data and consents to the processing of personal data. On the 12th of July 2024, the Commission informed the subject and sent the decisions on the recusal of two members of the Commission, namely National Member Nadezhda Hriptievsky and International Member Mirmantas Mikilionis, from the evaluation of his file. As a result of a random assignment of the evaluation file among the panels of a commission according to a procedure established in Article 17 of a Commission's regulation, the evaluation file of Eduard Varzar was assigned to panel B that consists of Virginia Moraru, Christopher Lehman, and Cornel Lebedinsky, taking into account the recusals of two commission members. On the 16th of August 2024, Mr. Varzar was informed by email about this, also about his right to declare recusal of members under circumstances established in Article 10 of the Commission's Rules of Procedure. Mr. Varzar, you did not request recusal of any of the Commission members. During the evaluation, the Commission collected information about the subject and his close persons in order to establish the subject's compliance with the criteria of ethical and financial integrity as provided for under Article 11 of Law 252. To this end, the Commission obtained information from multiple sources, such as National Integrity Authority, State Tax Service, General Prosecutor's Office, Specialized Prosecutor's Office, Territorial Prosecutor's Offices, Ministry of Internal Affairs, including the Super Council of Prosecutors, other public and private institutions, financial institutions, as well as open sources and individuals, natural persons. The panel analyzed and evaluated the information. So, with respect to the issues or unclarities found during the evaluation, from the information collected mentioned above and from the documents provided by the subject, the panel provided clarification questions and requests for confirmation documents. To this end, the prosecutor answered 4 rounds of clarification questions. The first one, on 31st of July 2025, the panel submitted the first round, and the 5th of August, the subject informed the Commission that in the period 24th of July 4 August 25 was on holidays and asked for an extension of the previously offered 12 calendar days to answer, which expired on the 12th of July by 5 more calendar days. The same day, 5th of July 2025, the panel informed the subject that it accepted an extension of a submission deadline until 12 o'clock midday of the 18th of August 2025. On 18th of August 2025, the subject submitted answers to round 1 and a part of the confirmation documents, asking for an extension of the deadline until the end of the week to provide confirmation documents for several of the questions asked by the panel, and there was a list of the questions to which you needed additional time to provide documents. On the same day, the panel informed the subject that it approved the extension of the submission deadline, and on the 22nd of August, the subject submitted the remaining documents requested under round 1. On October 8th, the panel asked the second round of clarification question, to which the subject answered in due time. On the 22nd of October, the panel asked for certain clarifications about comments in the answer to question 4, to which you answered on the 23rd of October, and on the 3rd of November, you sent the panel confirmation documents, additional ones, to the question from round 2. And again, we have a number of questions to which you provided additional documents. On the 14th of November 2025, the panel sent round 3 of clarification question, given 24th of November as a deadline for submitting answers. On the 17th of November 2025, you informed the panel that in the period 24th to 27th of November 2027, you were involved in a regional workshop, and you submitted the delegation order issued by the Prosecutor General, and you mentioned that for the date of the 24th and 25th, you will provide the information, the documents you managed to get by that, and for the remaining ones, you asked for a proportional extension of the submission deadline until the 1st of December 2025. On the 18th of November 2025, the panel informed the subject that it agreed to an extension of a submission deadline for round 3 of questions until the 1st of December 2025, also asking you to submit until the 24th of November the answers and confirmation documents that were available. On the same day, 24th of November, you provided some of the answers for round 3 and part of the confirmation documents, and on the 1st of December, you sent the remaining answers for round 3, and on the 2nd and 5th of December 2025, with delay, you provided confirmation documents for the 3rd question round. On January 6, 2026, the panel sent you the 4th round of clarification questions. On the 16th of January, which was the deadline for submitting answers, the subject, claiming holiday or in the period, being in a period of summarizing annual activity and reporting on various types of professional work, including involvement in work meetings at the interinstitutional level with development partners, as well as a sick leave that started on the same date, 16th of January, asked for an extension of the submission deadline until the 26th of January 2026 to provide answers and confirmation documents. On 19th of January, the panel informed the subject that it accepted the extension of the deadline until the requested date, 26th of January, and you provided the answers and the documents on the mentioned date. In line with Article 16, Paragraph 1 of the Law 252 and Article 28, Paragraph 3 of the Commission's Rules of Procedure, if, based on its investigations about the compliance of the subject with the integrity criteria, the panel or the Commission, if the panel or the Commission have doubts, they will send the subject a written notice presenting all of the doubts, and will establish a hearing that will take place at least 10 days from the date of the notice in order to discuss them. If the subject refuses to take part in the hearing, the panel or the Commission shall finalize the evaluation based on the information that it collected without holding a hearing. To this end, on the 27th February of this year, Panel B notified the subject that it finished the evaluation and found doubts about his financial integrity, which were going to be discussed during a hearing, and invited you to take part in today's hearing that was confirmed, and it takes place today, 12th of March 2026. The prosecutor confirmed the receipt of the hearing notice on the 2nd of March this year, and requested access to the evaluation case file, as well as asking in a closed hearing for at least a part of the hearing about aspects related to assets, income, and expenses of close relatives, parents and family of a sister, including the ones related to real estate, the beneficial ownership of which is assigned by the panel to the subject. On the 4th of March, the panel sent the subject its decision rejecting this request for a closed hearing. On the 5th of March, current year, the Secretariat submitted to the subject, provided the subject with evaluation materials in line with Article 28, paragraph 4 of the Commission's Rules of Procedure. On the 10th of March, the subject sent the panel his objections against the hearing notice, and on the 11th of March submitted additional documents supporting his position. Mr. Varzar, the documents submitted by you were not reviewed by the panel in relation to the hearing notice, but you can explain them during the hearing, and also I'd like to mention that they will be considered after the hearing, and if needed, the panel may request additional information or clarifications by means of an additional question round. Before we start the discussion about what was mentioned in the hearing notice, I would like to ask you two general questions. Would you like to make any additions or corrections to the answers or information you provided previously to the Commission or the panel in relation to the question rounds or to the documents that you submitted? I don't have any essential corrections to be made. Probably, revisiting my position, there could be a minor error about an amount of 400 lei. I don't think if it is correctly assigned to one flow or another, but I will check that and we will. It's not essential. It's not something that could change radically. I understand you. I understand. So what I provided, that's it. And my second question, your answers provided to the question rounds, as well as the information stated in your Declaration of Assets and Personal Interest of 5 years and the Ethical Integrity Questionnaire as a result of the notification starting the evaluation are still accurate as of today? Yes, they are accurate. I could only mention one aspect that I mentioned before as well. It is about cash savings as of 1st of January or 31st December of any year. I mentioned back then that the amount, the available cash is mentioned in the income statement on the date of filing the declaration, while the panel asked for some estimated calculations about disposable income on the first, at the beginning or the end of every year, so 31st December or 1st of January of every year. And I mentioned that these are estimates, calculations that I've made based on the information that I had available. I want to make it clear that these are not carved in stone, but at least so far I haven't found situations that from my point of view would affect somehow significantly the calculation related to that amount of cash. Even though they are estimates, they are somehow fitting the development of my financial situation, and I wouldn't claim that the amount would be 1,000 or 2,000 or I don't know how many. Could be higher or smaller. I mean, it could have been, but it does not affect the financial calculations related to the available cash. I understand you, Mr. Varzar. Next, we are going to discuss in much more details the aspects mentioned in the annex to the hearing notice, those doubts that the Commission provided to you, and I will give the floor to my colleague, Mr. Kornel Lebedinsky, who is going to ask you more clarification questions. Also, I would like to mention that at any stage of a discussion, any of the panel members could jump in and ask you questions related to what is discussed. So the priority topic mentioned in the hearing notice, or actually in the annex to the hearing notice, relates to inexplicable wealth in a total amount of 875,575 lei in over 6 years of the evaluated period. We're talking about 2014, 2017, and the years 2019, 2020. Mr. Lebedinsky, you have the floor. Esteemed prosecutor, before we start the round of questions and to be efficient in our communication, I would like to set some definitions that we could agree on in order to facilitate our communication. First of all, when we talk about Street M, we speak about all real estate that you and your family reside in. If a street is clear for you, it's okay. If not, we could take, and then we will mask it in the recording. Is it clear? Thank you. Secondly, when I say the word family, I mean on the narrow meaning of family. I mean you, your wife, and underage children, your dependents, because I will also speak about the family in a broader context, when I ask a question. Then all the notions and questions, the phrases will be general, based on the legal regulatory framework of Moldova. Thank you. And let's start with question 1. That is also the first doubt that we want to pay attention to. Esteemed prosecutor, do you recognize that actually you and your family are the beneficial owners of the apartment, parking lot, and non-residential space in Street M, which according to notary documents belongs to your parents? Of course, I do not admit that I am the beneficial owner of real estate. Thank you. We will come back to this question a bit later. Now, we will move to the second set of doubts, which relates to the difference between wealth acquired and your expenses for the years 2014, 2015, 2017, 19, and 20. Where the panel, after comparing information received from state authorities, financial and banking institutions, from your answers in the written correspondence, found a difference, a negative balance between your assets and compared to the incurred expenses. Let's start with the first year. Financial flows, incoming, outgoing of your household, of your family for the year 2014. Total incoming flow 711,709 lei. Total expenses 785,693 lei. In this way, the panel finds a negative balance, meaning that expenses exceed your income by 73,984 lei. Please confirm this. If you don't confirm, please provide an explanation about this table that was provided to you in the annex as well. I certainly do not confirm this. And I will make some referrals to the year references to year 2014, but they are valid for more years, so actually for all of the years. That relates to my disagreement. Some aspects are related to the first question that we discussed. And from the very beginning, my argument is that not being the beneficiary of those real estate, all expenses related to them have to be excluded from the table, because they were not incurred by my family, but by the legal owners of those properties. Also, when it comes to cash savings at the beginning of a year that are included in the calculation and the end of a year, there were several formulas or approaches that were debated during the question rounds about conversion of cash into available currency. And here, my disagreement or my concern is that the cash, especially for the this is actually valid for several years, but for the years where the available cash in currency was almost constant or was the same at the beginning and at the end of the year, meant that no expenses, no significant expenses were made from that cash and it stayed constant. I believe that it has, in the table with the doubts that was provided to me, it was calculated at the average yearly exchange rate of the previous year for the beginning of a year and from the current year for the situation of the 31st of December. And then, given the differences between the yearly exchange rates in the situation with 1,000 euros, I'm offering this just as an example, which did not change. So at the beginning of the year, the average could be 19,000 lei, the equivalent of 19,000 lei. At the beginning, it could be 20,000. And then there is a 1,000 lei difference reflected in expenses, and it somehow disadvantages the subject of evaluation. And also the situation can be opposite when the exchange rate is more beneficial at the beginning of a year. So this leads to situations that in an unjustified way are distorting the situation when 1,000 cash actually stayed constant, and we can't say that a person incurred expenses or had made profit. I made an analogy with the banking system and the bank turnovers, which are also an object of the analysis by you and the Secretariat and by myself, actually, in parallel when I made calculations. And just to make sure that you understand me correctly, I want to give an example. If from a bank account with an amount of 10,000 euros that were gathered for 3 years, why I'm saying 3 years, because it is possible for it to be like that, because 3 years was sometimes an argument that it is not clear the period. There's no clarity about the period of gathering that money, conversion. That's why you take the average yearly exchange rate. Indeed, that money could have been gathered for 3 years, and the exchange rate is 1 year is one amount, one rate, next year it is different, but I'm making an analogy with a banking account. So in a bank account, you have 10,000 euros gathered over 3 years, and in June, a transaction of 5,000 euros is made. And that leaves 5,000 euros in the account until the 30th of December in the bank turnover, account turnover. The bank and everyone using turnovers and calculations using the turnover data. The bank makes calculations as the date of a transaction, 5,000 euros turns into lei equivalent on the date of a transaction. And the other 5,000 euros stay in the account until the 31st of December. And on the 31st of December, they stayed in the account as the equivalent on the date of 31st of December. And for this account of a holder of the banking account, it's clear they had 10,000 euros, they spent 5, and they are left with 5,000 euros. If we analyze these figures in terms of annual average exchange rates of the year before the managing year, the year past, we would have totally different figures that are generated by the conversion. They could be to the advantage or disadvantage of a person.
And I thus believe that the optimal solution for such situations is the following. All the more so since the annex to the rules, the one that provides for the calculation methodology, over there, well, we don't see how is one to act in situations like this. What is to be done? What is the average that we take? The yearly average, the monthly average, the exchange rate on the day? In similar situations, we might be acting in different ways. So perhaps ensuring better consistency, having this consistent way of calculating things for the entire financial situation, for the 12 years, the one that is subject to the vetting, well, maybe that would be a good idea, and I've explained it, but you said that we would tackle it today. I've explained it in my objections to the doubts that were presented to me. If we had a situation of 10,000 euros in the beginning of the year, 10,000 euros in the end of the year, then the difference should be between 10,000 euros and 10,000 euros, and the balance would be zero. And in the calculation, we'd have a balance of zero. And then that should be done separately for Moldovan lei, separately for dollars. So we don't have to exchange anything in terms of as at January 1st and as at December 31st. And thus that could be either favorable or unfavorable, one year compared to the other. So when there is a difference, there's a positive one. In the beginning of the year, there was 10,000 euros. At the end, there are 15,000, or the other way around, 15,000 in the beginning of the year and 10,000 at the end. Then this difference can be regarded as either income, 5,000 euros that would be, and then we convert it as at January 1st. Or if the difference is, if there's a negative balance, then we can regard 5,000 euros as expenses, and we use the exchange rate at the end of the year. And thus, the developments, the dynamics of the financial situation in foreign currency, that would have been only about the 5,000 euros that either came in or left out, so to speak, in flowing or outflowing. So then we'd focus only on the 5,000. Either positive or negative balance, we would relate it to the period under question, and that part that remains constant, that shall not result in a misstatement of the actual situation. I, too, have put something down, some parallel tables that I've also submitted alongside with my objections. On the basis of the table that the Secretariat shared, took that as a starting point and made some adjustments, and I've also shown the situation just the way that I've explained it a little bit earlier, just now. So if there's an X amount, and at the end of the year it's an X amount, then when it comes to inflows, the balance, the opening balance, and then the closing balance in foreign currency X, well, that would be a zero if you compare that, and then the calculation should only be based on the national currency. And I think this is the best way, the fairest way to do it, the right way to do it. And I think that doing it this way reflects the approach applied by financial institutions. And if that is the case, then I think it's rather fair to do things the way I've just described. Now, considering this formula, having applied it, speaking of 2014, we can leave for later the matter about the beneficial owner situation. If there's anything you'd like to challenge a particular amount for 2014, I'd suggest that we talk it out at the time when you name it. But to begin with, I want to challenge the amounts that are deemed as expenses related to the properties. I mean, some investments for 2014. So, speaking of 2014, what amount do you disagree with? The 91,524. I mean, the one that is related to the investment contract. 94,400. Which one is it? No, there was the 91,000 in 2014. 91,524 lei. 91,524 Moldovan lei. And that is the one that you disagree with because you disagree with the beneficial ownership. That is correct. All right, thank you. Now, considering what you've stated about the exchange rate situation in terms of lowering or increasing the amounts, I mean, what is it that you believe that you would like us to pay attention to specifically? In the tables, as I've just stated, if we compare things, well, taking into account those differences, then it would turn out that there is an overstatement, a 2,000 euros overstatement, or like that is the difference between the cash available in the beginning of the year and cash available at the end of the year. The difference is 2,000 euros. 2,000 euros, that is the equivalent of 37,260 lei. So as regards the cash, I've inserted over there for the incoming flows 0, outgoing 37,260 lei. Thank you for the detailed answer. And then, if I may, clarify so that we avoid repetition. The formula that you suggested, so the explanation of your formula, that is to be applied to all 6 years, correct? And every year you're going to put down the number that reflects your calculation. Is that correct? Yes. So as a result of adjustments to these amounts, taking out the 91,524 and thinking of adjustments to the cash savings in the beginning of the year and end of the year. So what is left is just an outgoing flow, the 37,260. And if we put together total income, total expenses, the balance would be a positive one. 70,065 lei. Thank you for your explanation. We will look into that. But I have a follow-up question. Considering that the vast majority, at the end of the year and beginning of every year, you report savings in euro, in foreign currency, in euro. Now, my question is, this amount remains intact throughout all of the years from 2014 through 2020? Or did you use it? Did you perform any transactions with it? Did you use it to pay for certain things? Because that too will allow us to look at things in a different way. All the more so since you've explained this in the additional explanations you provided in the hearing. You provided a number of annexes with different exchange rates. Thank you. Now, as for the exchange rates, I have printed that out in order to be able to comprehend the approach of the Secretariat in making the calculations. A lot of information wasn't available. Some calculations for certain expenses, there were some amounts that were hard to make sense of as to where did this amount even come from. What was multiplied by what? What was the exchange rate? So I printed that out and I've annexed this to the set of documentation because I categorized that by questions, by rounds. And I've annexed that along to show what I had used for this calculation and exercise. And on the basis of those tables for the different years, you can see that from 2014 through 2020, well, for that period, speaking of significant expenses, in 2014, 18, I mean, there were some expenses incurred in some particular years, but they did not affect the available cash. And you can see across different years there are some differences. There are some differences in terms of cash, either upwards or downwards. So that was the dynamics of the cash from January 1st until December 31st. Some procurements were made and covered with cash saved throughout the year that did not impact essentially the available cash on January 1st. The cash was available on January 1st. And as to how things have been evolving, you can tell out of what is shown on January 1st and December 31st. So the amounts are practically not essentially different. In the previous years, there were some expenses, and that can be seen in the corresponding differences. Now, to have better clarity, and we'll go back to some of the details as we go along with the hearing, but that amount at the beginning of the year and at the end of the year, that was intact, and you were only operating with the cash from salary and other sources of income? And did you exchange it and use it, or were these amounts involved in the transactions or not? And then at the end of the year, you put the money back to have that same amount that you reported as saved amounts, so that we know how actually this was happening. Was there an amount? For instance, you had an amount X in the beginning of the year, and then say you set that aside as savings. I'm not going to touch it. It's there until December 31st, intact. Is that how it worked? Or is it that you had an X amount at the beginning of the year? I used that money throughout the year, but then with the income that I earn, I put the money back, and then at the end of the year, I have that amount back, so to speak, but on the basis of, well, having put back the amount over there, the savings from my earnings throughout the year. It could have been possible to use some amounts. That could have been the case, but not for lengthy periods of time, and not those amounts, the money that was used, that could have been used, were not that significant. So for, well, temporary, I believe that perhaps some money could have been used if there was a situation that was not foreseen ahead of time, and then shortly after that would be compensated back, and then, so to speak, I'd put the money back. Thank you. And this is where my question is stemming from. The amount that was reported in the beginning of the year and the end of the year is in euro. And as you've stated recently, that some expenses could have been incurred and then put back, and your main income, that is in Moldovan lei, national currency. What were transactions like in euros, exchanging that and making sure that you have that reserve in currency, in foreign currency, through banks, through exchange facilities? Because we wonder how that happened. From financial institutions, we did not receive any information in this regard, and we did not receive any explanation from you regarding this. So we'd like to know what your position is regarding this matter. Well, that could have been purchased indeed with currency exchange offices. And I've also mentioned something about my business trips. Often, I would, for instance, be able to use my own available funds to go away on a work-related trip, on a business trip, and afterwards that would be reimbursed in the last days of the trip by the Council of Europe in particular, and then I would be back with the equivalent of my expenses, and I would put that back. So those reimbursements, that was the only income. Was that the only income that you received as a, so to speak, compensation in currency, in foreign currency? But to a vast majority of your incoming flows, that's in national currency. The vast majority of your inflows are in national currency. So that's why I am asking. How is it that you are exchanging national currency into euro currency to set aside your savings or to replenish them? And were the national requirements observed in terms of a person having to identify themselves when they exceed a particular amount to be exchanged? You know that those provisions exist in our law. The amounts concerned, well, I mean, there weren't any transactions involving significant amounts that would trigger the need to identify the client, the customer. Therefore, I mean, there wasn't even a need to do so, because from the very beginning, those amounts would come in euros, because that was being amassed. I mean, the most part of that comes from wedding donations that were kept by the family like that, and thus there weren't significant purchases of foreign currency. And what I reported as donations from family events, that corresponds to the value of these savings. So nothing, no big amounts were purchased in terms of foreign currency. Thank you for your answer. If there's nothing else for you to add for the first table, if my colleagues don't have any questions regarding the first table, we can move on to the second one. Chris, checking with you if there's anything you'd like to clarify regarding 2014. Anything to clarify about 2014? Well, if not, then we shall move on. Esteemed prosecutor, let us move on to the second table, incoming and outgoing flows for 2015 regarding your family. Over here, there is yet another difference. Total income, 708,194. Total expenses, 1,032,518 lei. The negative balance, 324,324 lei. Now, would you comment on the information in this table? Tell us whether you agree or disagree, and how would you argue that? So, your explanations regarding the beginning of the year and the end of the year, do you still hold or stick to that explanation? Yes. Well, then, can you single out the amounts that you would disagree with on the basis of your calculations, and if you could provide supporting explanations? I disagree with the amount for the real estate, for the property. The 268,500, that is the amount that I challenge. That is the payment for installments as per the investment agreement. Okay, thank you. Otherwise, now, to make sure, your explanations relate to the fact that you do not admit to being the beneficial owner of the assets. That is correct. Thank you. As regards savings, well, they're put in one single position, cash, bank savings at the end of 2014 and 2015. And in the table that I have shared with you, you can see that I've separated them depending on, well, on the basis of how the Secretariat separated them. So those amounts, the 4,485 at the beginning of the year and 5,600 at the end of the year, well, those savings in the bank, I've put them separately in different positions, as in different cells. Though I don't know whether it is now or for other years that I have to mention this regarding, but when I made some calculations, I did something differently, and there was a difference from the savings on a bank account. So there are some differences, not significant, some few hundreds lei or 1,000 lei maybe. I do not have objections as to the doubts, so I did not insist on those differences. I put together some calculations on the basis of the turnovers that I had available, and I was not able to identify what values were introduced in the calculation formula for the amount of 4,485, for instance. So, given that, well, those differences, January 1st, December 31st, the differences aren't significant across what I calculated compared to what the Secretariat calculated, but I did not address that because the other amounts, if accepted, they practically solve the balance issue, turning it into a positive one. What do you mean when you say the other amounts? What do you mean? It's what I said earlier, that the payments for the investment agreement, that's 268,500. Is that what you speak about? Yes, that's what I meant. So if this is accepted, then if we were to debate that if we accept that, then if we compare if it's 4,485 or 4,885, I mean, it's just a few 400 lei difference, I don't think that there's really significant for the balances. So according to your estimates, if you made some calculations, carry out some calculations, and if you take out the 268,500 amount, that what is the positive balance that you have calculated? I wanted to say, yes, that if you put this amount separately, I wanted to anticipate that for all the years, I submitted some amounts for the bank balances. They were a little bit different, but I didn't go back to them now for the reason that they do not impact the situation significantly. Going back to, well, excluding that amount for the investment agreement, and if we apply the formula regarding the cash in the beginning of the year and December 31st, and for, well, 2015, the cash was the same in the beginning of the year and at the end of the year, and thus I have if we exclude that, the incoming, outgoing, the existing amounts, and the balance for euro, that would be zero. I made some calculations for the cash flows in lei, and I ended up with inflow 158,595, outgoing 147,000 lei, and the balance, positive balance, is 11,000 lei. Around that. So that is a positive one, positive balance. Yes, as per your calculations, understood, prosecutor. That is why we are holding a hearing, to give you the possibility to share your opinion, your position regarding the findings and doubts of the Commission, so you are free to share with us your views. Thank you. There's nothing else for you to add regarding this table. Let me look at my colleagues if there's anything they'd like to ask. Just a clarification question. Regarding 2015, if I had gotten it right, what you challenge is the cash bank and banking savings at the end of 2014 that are in the incoming flow. Total amount is 554,084. And the cash and bank savings at the end of 2015. And so it's table number 2, right? Is that correct? And the total over there is 622,392. So these are two different amounts, and we cannot regard them as identical to take that out of the formula, so to speak. You've stated that, well, I challenge the calculation for exchanges for the 29,500 euros, that the exchange of that as at January 1st and as at December 31st, because that amount remained constant throughout the year. Yes, but it includes at the end of the year cash savings as well. So you think the difference of one day, the one-day difference affects that much the exchange, hypothetically speaking, when we exchange that? I don't understand. What do you mean the one-day difference? Would that be a difference if we exchange, say, 100 euros, for instance, if we exchange that at December 31st, 2014 and January 1st, 2015, do you think there is a bigger difference in terms of the exchange rate, a huge one? No, I think that the rate as December 31st is the same for January 1st until only on the 2nd of January they have a different rate because it's the first working day. But the formula is different. For the inflow, for amount X, the average rate for the previous year is applied as calculated by the Secretariat. And for the same amount that remained throughout the entire year, at December 31st, a different exchange rate is applied. Understood? For the year 2015, that would be. So that's what I meant. So it would not be fair, it would not be correct, it would not be in compliance with calculations made by financial institutions. So that's why I say that the same amount that is on January 1st in foreign currency, in this, I mean, I'm speaking about foreign currency, and I repeat, the one that remains constant throughout the year, so then the holder doesn't have any profit whatsoever, or income, or expenses, or anything. It's just there. So it's not fair, it's not right to capitalize, so to speak, on this exchange rate differences and to make it look like income or expenses. I mean, one year things are one way, and then another year they're in a different way. And I've applied that formula not just for the years that aren't favorable to me. I did not even make a calculation to see where it's favorable and where it's unfavorable. I just noticed that there is an issue that somehow is hard to wrap your head around, especially since the methodology does not provide for any solutions for this situation. And I drew a parallel with how the financial institutions work around it. And I took the bank turnover, and then you look at what goes out of the account, or I mean, they make calculations of the equivalent in national currency as at the date of the transaction. 100 euros went out. That is calculated as at the rate right now, not as at the rate that the euro, that 100 euro entered the account a year or two ago, for instance. Understood. Thank you, Chris. Let's move on to the third table for 2016. Total income 933,033 Moldovan lei. Total expenses 1,214,111 Moldovan lei. The negative balance is 281,078 lei. So, same way as before, let us know what is it that you disagree with, and if you disagree, what are the reasons for that? Similarly, investment in constructions, there are two payments put down there, 176,446 and 30,940. That is under a different investment contract. That is correct. Two different properties. That is correct. So these two amounts I disagree with for the same reasons as regards who the beneficial owner is. Concurrently, in the table that I've made available, with calculations that I performed on my own, following the same formula, well, I focused on the idea that the cash flow in foreign currency, that has increased by 500 euros throughout the year. And thus I've reported in outgoing flows the equivalent of the 500 euros. Otherwise, the rest of the amount, I left it as it was. So then I just, for the outgoing flows, I've calculated 11,025 lei. That's my calculation. So that would be that increase in foreign currency cash. Also, for procurement of car in 2016, I submitted documentation with a value established in euro, purchased in euro on December 5th, if I'm not mistaken. There is supporting documentation containing this information. And there's another vehicle, a trailer, that was purchased on April 7th, 2016. That is again, that is the date of the procurement. And I've made some adjustments, or rather I'd suggested some adjustments that want to come through right. I don't change, I understand the amounts automatically only by saying so, but I decided to include the value of these properties of the vehicles in the calculations on the basis of the exchange rate on the day of the procurement of those two vehicles. So as at the date of their purchase. So I provided explanations everywhere where this flow comes into question. I provided my own commentaries. It's only that over here the amounts are more detailed. So that is about the what was paid, 5,172 euros as at that rate, and for the trailer, 529 euros. And that is as at the exchange rate on the day of the procurement. I think it was greater than the average cost for I don't know what here. And I use that because it's the day of the purchase, not that I chose a rate that is the most favorable.
Still, I believe that the approach needs to be uniform, and if we have a date of a purchase, drawing a parallel with the bank account from where I withdraw 500 euros, that is the equivalent in lei on the day of the withdrawal from the account. If I may ask you a question here regarding your position, we want to understand how to assess things. I reiterate, we were not, as a Commission, provided with documents that would prove the purchase of currency. As you are saying, the amount, the declared amount, 180,000, is a big amount that would, to buy it, a client identification through the banking system would have been necessary, which means that even currency exchange desks in relation to ALM and counter-terrorist financing legislation, AML and counter-terrorist financing, they would have asked for documents, and no one provided us with documentation that on that day you had any exchange transactions, which means that you used money that you had at savings at the beginning of the year, and maybe later during the year you compensated it, so that as of the 31st of December you'd have that reserve of cash. So the formula of apply the rate on the date of transaction is not always applicable unless we have a confirmation that that's specifically the date when you purchased the currency, because you could have purchased that amount years before or kept them from the wedding, as you were saying before, and it was in a different currency. I understand what you're saying. If we accept this approach, then we should apply the average exchange rate when we treat a transaction from bank accounts. When an amount of money migrates, we should go and look for the exchange rate that amount entered the account and apply the currency exchange rate on the date when the money entered the account. Sorry, but in the banking system and bank transactions, account to account, I'm telling that as an employee of the banking system, the procedure is different, and the conversion or moving from account to account differs from transactions between individuals. I'm not speaking about necessarily from account to an account. I put on my account 5,000 euros today. 1.5 years later, I'm making a transaction of 4,000 euros. Do we treat that procurement, the price of that purchase in lei, is it the equivalent of 4,000 euros of the date of transaction, or equivalent of 4,000 on the date when the money was put into the account? That's the difference. Do we treat the date of transaction as a point of referral for the exchange rate? I wouldn't like to start a debate on this topic. I just want you to understand me. I understand your position. I'm drawing a parallel so that I would make sure that you understand what I want to say. Regarding the purchase of the vehicle, 1 or 2 months before that, buying that vehicle, I sold another vehicle, and that was the source of a part of the money. And, well, for the remaining sum, you save some money every month. You exchange 100 euros without identifying client, or 200 a month. You put it to your savings, having the intent to replace your car. You are preparing and you make some reserves, or you make some plans, forecasts. And of course, it couldn't have been a purchase of currency identified somewhere in the amount of the price of a vehicle, because part of the money came from selling the previous car, and some of the money was saving over the year, and the purchase was at the end of the year in December. That was the thinking. At the beginning of the hearing, I clarified that the amount that is it the amount held over the years, or is it a process of taking out and putting in money? You gave an example of adding to that amount over the years, and the amount migrates, even if the amount is the same at the beginning of a year and at the end of a year, but over the year, you play with it in the way, you compensate it, you take money from there and put it back. Thank you. Do you have any other objections to the table? That's it. Then, could you explain, according to your calculation, what would be the total balance with all adjustments that I mentioned, with cash and with the value of the 2 vehicles, and excluding the 2 items about beneficial ownership? The negative balance is minus 35,890 lei. And how do you explain it? That negative balance of 35,000, if you accept it. I mean, you obviously do, because that is your calculation. And how do you explain it? I cannot, right now I don't have an explanation. One thing is certain. From the background or historical evolution of events, I have never had a situation of a financial crisis or that would now serve as a justification. Honestly, there could have been some decisions. I mentioned that at the beginning. Maybe the savings in cash were a bit different because, as I was saying, those were estimates. And maybe on the background of the savings, this negative balance would be generated. But I do not insist on seeking the truth at the bottom of the oceans, because it is an approximation, it is an estimate, and I don't want to extrapolate based on this specific. Thank you for your explanation, Prosecutor. I'd like to ask my colleagues, do you have any more questions about this table? If not, let's move to the next year. And that will be year 2017, when, according to the table you were provided with, we have total income 1,597,545 lei and total expenses of 1,677,844 lei. Negative balance of 80,298 lei. Following the same formula. Do you confirm or not? explain what's your position about this table. In the same context, this is well, again, regarding beneficial ownership, I object again I challenge this amount from the same perspective, and the savings in cash at the beginning of the year and at the end of the year are the same amount. The balance of the difference between them is zero. That's why I suggested the formula that them being identical to have a zero balance, to exclude them from the equivalence of, so according to the formula explained previously. Yes, and if your calculation, the final balance is positive of 21. Thank you for your explanation. This is also a mathematical perception, logical perception. So the amount that I object to, that's the amount to which the balance varies, the balance that I've calculated. Thank you for your explanations. Colleagues, do you have questions to this table? If not, let's move to the next year. That will be the difference for the year 2014 before declaring the incoming outgoing flows. As you have noticed, the panel made a table through the same perception as beneficial owner from that street that included contractual expenses related to the real estate. But in order to keep the fairness and logic or rationale of the thinking, we did not include in the tables from 2018 the amounts you declared according to rental agreements that varied over the years from 405,000 to 7,000, more than 7,000, 6,000, sorry. Excluding the amount for the rental, we have incoming. We have 10 million. Sorry, not. I apologize. Not 10 million. 1 million. I would have liked to have 10 million incoming. May God help you get that. I will repeat it. And I apologize for the mistake. Incoming flow 1,082,592 lei. And cash expenses in 2019. This year is only, this table is only about cash flows. Total cash expenses 1,159,750 lei. Negative balance of 77,158 lei, excluding the expenses declared by you as yearly expenses for renting the real estate on Street M. Do you accept it or not? Of course I do not. And I have explanations, and I did it before. I provided objections to your notice of doubt. Partially, I've seen some updates or acceptance of some amounts, but I believe that not all amounts were accepted. There are some errors here and there regarding the perception of certain operations, and I will explain that. For 2019 specifically, I expected a calculation of income and expenses as in the previous years, as provided by the calculation methodology from the annex to the regulation. And for the previous year, I saw you analyze the cash flow, but also a comparison of income and expenses. So in the end, for the year 2019, only the cash incoming and outgoing flows was kept. Why am I saying here that it is not reasonable? I just want to make sure that you understand me correctly. Why it is not reasonable to focus on these flows only? Because if we look only at cash, then we need to take into account a number of aspects. They relate to certain cash operations or cash flows that were not taken into account because they were somehow treated as flows that covered some travel expenses. They were received for travel expenses and they were spent for travel expenses, but that would be in an ideal situation when you are paid in cash and you spend them in cash, or they are paid to your bank account and you spend it from the bank account. There are other dimensions to it that need to be considered as well. And I attached to the objection to your doubts in a separate Excel file all of the transactions that I believed to be useful for the calculation, which reflect expenses incurred during the trips in 2019 from the bank account. I received in the Annex 2 of 3, or 2 and 3, I don't remember precisely, a list of transactions that that were made in relation to the trips, business trips, but they were not all reflected there, and I found another list of where I included all expenses, both business trips and vacation travel, because the value of vacation expenses that was submitted in round 1, if I'm not mistaken, that was treated from the beginning as cash expenses. And they were moved here into outgoing cash flow as a total value. Even though a significant share of them were paid for by card, and in the first round that was not asked for, and no specification was made about how they were made, cash or card. It becomes, well, it is visible there that in some cases I wrote a specific amount in euros that coincides with the value of the transaction paid by card. And if we cross-check some amounts, it makes sense, the things that I'm explaining right now. So that annex includes all the amounts that should be included into an incoming cash flow. In round 4, there were accepted expenses paid by card for The purchase of tickets and accommodation en route for colleagues from the delegation that was going on that business trip, but there are some errors in there. The business trip of July 2019 was interpreted as if I had incurred 562 euros expenses for accommodation shared with a colleague from the General Prosecutor's Office, and that amount, I think it was done through Booking. Or actually, it doesn't matter what platform was used. It's in the turnover. It was incurred, and that is the amount that was reported under vacations in Croatia in 2019. During that travel trip, that included some days, a few days deviation from the established route, because it was a deviation. It was a trip by car with family. There was a detour for a few days, for a week. And for that week, the payment was made as vacation, not as a business trip. And for the business trip on July, I did not incur expenses that would have been shared, or expenses for the colleagues who would have reimbursed me in cash. Those were vacation expenses that were made from my bank account. And then to the flow of vacation expenses in cash, we need to subtract these amounts. I also attached a table where I tried to describe, to depict the situation of business trips, to make it easier to understand from a mathematical point of view, because there are many of them, 5 business trips, and for 5 vacations or some occasional visits across Prut. I don't know. I will try to be very brief, but to make sure that I explain it in a clear way. I have it here in a elaborated way. I don't want to read out everything that I've written, but the amount of 13,000 lei that was shared or reimbursed by colleagues on the letter A of paragraph 81 is not challenged. It is like that, it is okay. Letter B of paragraph 81. You mentioned the amount, the equivalent of 562 euros, 5,159 lei, and that was not incurred in relation. Come again, equivalent of 562 euros, and in lei you said 5,859 lei. So it's not a mistake. It was treated that the amount of 562 euros was shared. Okay, shared, then I understand. Shared with a colleague. And I said that that would be the equivalent of 5,859 lei. And I'm saying there was no sharing there. 562 euros were related to my vacation with accommodation in Croatia, which has to be subtracted as a card payment, not cash. It had to be taken out of the cash outgoing flows. That's okay. Letter C. The amount of 12,192 is written in relation to the business trip in December 2019. And also in your notice of doubts, you mentioned that the panel has not found other card payments related to that trip, and all expenses were incurred from one bank account only. That was accommodation through booking, but in the report it's through Airbnb. I just want to make sure that clear in order not to get misled when we analyze, to avoid any unclarity. The accommodation expenses were shared for 4, not for 3, as the Secretariat treated it, because accommodation was shared with a colleague from the National Bank who was traveling from another country and then leaving to another country, but the accommodation was for all 4 of us in the same place, because it was December, and in December it's really hard to find accommodation in Strasbourg given the Christmas markets, delegations to the Parliament, to the Council, and you are looking for solutions. You take a large apartment that is expensive, but if you share it to 4 people, it is accessible, and the transportation was covered by me for the other 2 colleagues, and then that is shared to 3. But the accommodation was shared to 4, among 4 people. I attached the calculation in the table, but you have all freedom. Let's not start additions and subtractions here. But payment for plane tickets were to be divided to 3. There were 2 more business trips. So this division, this sharing, relate to the trips from April 2019 and December 2019 to Strasbourg, to the Council of Europe. Speaking about other business trips, I had one in October to Strasbourg, and July. As I said, that was joined with my, merged with my vacation. These ones were not shared with colleagues, but for these trips, the accommodation, the tickets, and maintenance expenses, both in July and in October, they were paid by card, and they are all included in the bank statements that are merged in an Excel spreadsheet, and altogether they were paid by card, and they were compensated in cash by the Council of Europe. So their value has to be included into cash incoming flows, because they were made from a bank account, but I received the compensation in cash. Sorry, one question. These amounts compensated from the Council of Europe, according to in your declaration of assets and personal interest that you finally filed to NIA, do you include them there, because they are significantly essential? These amounts were not included because we discussed repeatedly with representatives of NIA, and they said that this is up to each and everyone. Some of them report them for some reasons, but they are expenses related to business trip and living there, so they are not subject to the law on declaration of assets and interests. To clarify here, in the section of the annual declaration of assets and personal interests, we have salary income and we have other income, where it is written that it includes pensions, compensations, and allowances or indemnities. Given that the compensation is not strictly under the law on social assistance, compensation for disability, for instance. Compensation includes all kinds of compensation of expenses, for instance. This incoming cash flow is otherwise creating a calculation issue for our colleagues at NIA who are checking the declarations. So, because in that case, incoming and outgoing flows will generate a disbalance, even though we do not try to deny the legality of these compensations, but in terms of a principle of transparency, I think declaring that income would add value to you and not damage. Thank you for explanations, but I just wanted to understand it. Yes. I did not think to treat them as compensations. They have a name, per diem and accommodation expenses and travel expenses. These are universal notions in international law, and they are called subsistence allowances, per diem, and travel expenses. So I have never thought that they could fit into the compensation notion. However, I'm not saying that those are income. I'm saying, well, you're right. Income and calculations, but I'm not saying that they are additional income. I'm only speaking about it from the perspective that we are analyzing cash flows. And then we should treat those tickets, flight tickets, and bookings that I paid for with my card, could perceive that I took them out in cash. I bought the ticket for a plane, and I paid my accommodation, and then we transfer them to the cash flow when we take money from the bank card. But if we pay by card directly, it is not reflected. But in the end, they are compensated in cash. Your logic is clear. It is just a compensation. It's not an increase in income because we... Exactly. I'm not treating it as an income. I'm treating it as a compensation. And that's what I was saying. The fact that you paid it transparently by card, no one has anything against that. But the money, the amount that was given back to you to cover, to reimburse the expenses that you paid by card, it falls into income. To get into a zero balance, you pay by card 100 euros, and you are getting a compensation of 100 euros. So you had a cash out 100 euros as an expense, and as a compensation for that, and on the incoming side, you receive this money. So it comes as a compensation of expenses you made, and the balance will be zero, of course. The balance will be zero in the end because this is a compensation of what you paid by card. You get cash instead, but it is not a transfer from one side to another. It's just a trade-off between them. Plus and minus are getting into zero. From an accounting point of view, sorry for intervening here. I just wanted you to have clarity, for you and for us.
I have a very good understanding of this. I got it. But now what I am speaking of is the need to treat that, those amounts from those trips, and not entirely, but in the amount that was incurred and covered with funds from the accounts. So I think, we could further engage into debates regarding this with ENIA, and perhaps, for years in a row we've been talking to them about it, but I haven't seen an initiative from them to finally settle this matter. And so, speaking now of these amounts, trying to get to the bottom of it, in total, what we have is, I systematize that here briefly to support clarity. So, the flow, the cash flow, the inflow, so the Secretariat has taken into account and included 31,059 lei. You mean the cash reimbursement? That is correct. And if I follow the logic, my logic, that would be 91,940 lei. And this would consist of expenses from bank accounts compensated in cash by the business trip colleagues, so 31,000. So that would be effectively 34,528. So 34,528 expenses, that is in lei, expenses from bank account compensated in cash by the Council of Europe for 4 trips. So that is for expenses, for my expenses, specifically my expenses, not separately for my colleagues. So that would be 34,434 lei expenses from bank accounts compensated in cash by the EU project for trip to Finland. And the Secretariat, in that regard, did not take into account any of the amounts, despite the fact that supporting documentation was made available. And that would be the equivalent of 16,464 lei. That's expenses paid for with a card. For the Helsinki Hotel and Turku Hotel, paid for by card throughout the business trip. So the payments were incurred for the time that I was in Helsinki and Turku, and I think that that is something that must be taken into account, certainly. And there is a transaction in Borispol, Kiev. There is a ticket, and you can see Chisinau, Kiev, Helsinki, Helsinki, Kiev, Chisinau back, and there's a transaction in Borispol airport. If you pay attention to that, you can see that. And that is the money that is tied to, linked to the business trip expenditure. And another expense, well, there is for charging the phone, so some phone replenishment that also paid by card but compensated with cash. And the proof of that is, well, the substantiation is that, well, the way it was written was that not enough evidence was submitted as to the cash. I submitted the correspondence that I found on my professional mailbox. The project coordinator was there, so the correspondence with project coordinator. And so things have happened during the trip. That was from November 24th, I think that was a Sunday, the 24th of November, on a Sunday. That's when we departed, 2019. And then I also showed the correspondence on the week before, where the people with responsibilities from the project, those in charge of the project, wrote to all of the representatives of institutions that were supposed to go on this trip, and especially to the NAC. Because somehow that's where everybody had gone to take their per diems. And out of the email correspondence, you can see that the EU project representative says, we kindly ask the NAC to allow a particular person access to the headquarters, because that person will hand out to all the participants cash for the trip expenses. So out of the correspondence, you can make that out. And then there were tickets and the flows on the card. You can realize that, well, there were 2 payments for the hotel, and that was covered with money paid in cash by the EU project to the participants on that visit. And just one day before, you can see that there is a replenishment of the euro card with euros, my card. I did not manage to figure out what was the value of that particular transportation expenses and per diems, but I've annexed and I tried to, and I've gotten in touch with, because I had the phone. It's only that that person is in a country somewhere at the other end of the world, and does not have access to the data anymore, and was not able to provide what I sought, that is, information on the amount that was given to every participant, to every person on that trip. But I have replenished the Eurocard, and I've also annexed a regulation of the EU that stated the value of per diems and expenses for hotel, for accommodation in 2018, 19, a few years in a row. And I think it was 255 euros a day, if I'm not mistaken, for accommodation and per diem. And 24th to the 30th, that was 6 full days. By 255, that's a bit more than 1,000 euros. From my card, I've spent 830 for the hotel, for accommodation, and about 40 euros, what I've already stated, at the airport, and for some phone expenditure. So the value of these expenses from the card, that's what should be subtracted from the flow, or actually should be related to the inflows, that should be regarded as an inflow. Or we can, what was the amount to top up the card one day before the trip, that should be subtracted from the flow of what was deposited on the account. I think you have that position, amounts deposited on the account. So the 1,400, that's one thing, and then the 850 euros or whatever that was, that's a different thing. I said 850 that I have actually paid by card, and I'm sure about that amount. Now, what was paid by the project, we can just figure it out more or less if you multiply by the number of days. But it's about, what, 800, more than 800 euros. That has to be subtracted or reflected as an inflow because I have recovered that. I spent that with my card, but I recovered that in cash, as I've explained. If I may, Mr. Varzar, a clarification question. Now, with regards to what you just stated regarding the compensation for those expenses in cash to you and other colleagues of yours at the NAC, and you've mentioned that email correspondence. If I have gotten it right, the access of a person from the Council of Europe or from the project funded by the Council of Europe, by the European Union, so somebody asked for that person to be allowed to the NAC headquarters for that person to give you that money in cash. Did I get you right? Is that what happened? It's only that, well, yes, but all the organization sessions, I mean, there was the Minister of Interior, I understand, there were people from different institutions, that is correct. And for discussions, people would gather at the NAC. We were having that as a joint meeting, so as for everybody to be explained all at once. It's like a preparatory meeting before the trip. I think 2 days before that, on Thursday, actually, and then we left on Sunday. And the message, because it is annexed, the message stated that the NAC was kindly asked to allow that person in. So you also said that we can deduce that out of that correspondence. We want proof of the fact that you received the money and that your colleagues of the trip, that they've also received it, proof of that. In this regard, did you take any action with the EU delegation or the Council of Europe who funded it? Did you get in touch with them about this? Because in 2019 there were a few of them. Well, you claim to have been reimbursed those expenses in cash by representatives of those institutions. I don't know, maybe it was the finance department or accounting department. All of those pieces of proof, of evidence, they are kept usually by the accounting department or whatever it is called in this organization. So you don't even have to call the project coordinator. The accounting records are usually kept duly by institutions, by everyone. So did you try to get any proof of that for the cash amounts? Because I imagine that same as for any other transaction, regardless of who you enter into the transaction is with, you have to sign something. It's not like nobody kept record of those expenses or of the money that was given to you in cash. So you certainly have signed something. Is it possible for you to get those records? Is it possible for you to get those confirmations that you were paid back the amount of X amount of euros as at that date or on that date. I did not attempt to do it because I had identified, I believed, enough evidence of that trip. There's an order of the Prosecutor General, but this does not confirm that you were paid that money like that. And we're speaking of transactions, of expenses, of cash inflows in terms of the credit and debit for 2019. So we are in particular interested in the cash that you received and spent. Is it possible for you to get hold of that information that we're asked about? Well, tomorrow already I can file an application in that regard to give it a go, and well, I don't know as to the outcome of that and how fast they would respond. The amounts that you claim, they are considerable, including the ones that you've shared with the colleagues, though, and then in the individual expenses and reimbursements. So what we shared with the trip colleagues and the accommodation expenses, that's regarding the Council of Europe. That's where the Council of Europe is concerned, and I provided all the information. They did not give me that for the entire period, that information. They did not find that at the Council of Europe. So whatever I managed to get, that's what I shared with you. They did not cover all the years and all of the trips. However, for 2018 and 19, sorry, for 2019, I was lucky enough to have the information for all of the trips in 2019. Given that with the Council of Europe, I mean, there are things that are being kept for a particular period of time, and well, it's 2019, it's not far back, really. And then there are situations in practice, and it happens in my practice, for instance, as well, when it comes to expenses for trips in year X, when that was reimbursed by external assistance projects in the following year, for instance, a few months later. So that is the flow that we're also interested in to know how things were handled. I will seek that information. I just thought that what I managed to get, if you analyze all of that together, taking on board also the expenses covered by card, and given that everything matches, the hotel, the town that is named in the letter, seeking and naming the people to join that party or that trip. So they are all somehow connected logically that allow one to see the full picture. The two payments for two hotels are the two payments covered by the EU project and were paid for in cash, actually paid for by card, but then compensated by cash given to the participants a few days. We wanted to make sure. Microphone, please. So that is specifically precisely why we wanted to make sure that you had received those amounts that you have claimed that you did, so that we can further on make potentially changes to the amounts that you disagree with. That is the reason for this inquiry. Thank you. Well, that was about Finland in the last position. Those were expenses related. Well, that was 6,514 lei, that amount. And then was 3,877, if I'm not mistaken, for the December trip to Strasbourg. I made some purchases, and they are reflected in the bank turnover. On that account, in the account activity data, there are some purchases that I paid for by card, and a part of the amount was for something that I bought for my sister. Some goods, some items. And their value, there were two transactions, but totaling 200 euros, the equivalent of 3,877 lei, or around that amount, and that was not taken into account. That was recovered, that was given back to me in cash by my sister. The sister gave that money back to me in cash. That was before the pandemic, because the pandemic came up in the discussion. That was the last trip before the pandemic, in December 2019. And there is a statement from her that I made available, and in the last set of documentation that I produced. And in that statement, she confirms what I just stated. And in addition to that, there was another amount. So yes, indeed, that was 3,877. And 2,637 lei, that's expenses incurred in Romania on August 27. For my parents who traveled, who were there for a one-day trip, they visited a family in Romania. So those were expenses covered by my card, and they gave that money back to me in cash. These two amounts, they total 6,514 lei, and I think that that too has to be shown as a cash inflow. And then speaking of vacations, what we've addressed earlier as well, the Secretariat took into account and deduced the fourth round, I think, the 28,091. So, in the table, I've performed some calculations reflecting the transactions by card while on vacation. They have to be deducted from the total amount of 55,000. That is that amount that was initially reflected as vacation expenses by cash. So that was 55,000 and something. So another clarification question. In the context of the doubts regarding the beneficial owner of the real estate on M Street, so in that context, I told you earlier that the Commission did not include in the cash outflow, the expenses for rent as per the contracts you and your parents entered into. And that is also true for 2019. Now, in your calculations, did you include annual expenses for rent? Or do you not include that? And just let us know how would you explain that. I'm looking at it and I might have omitted including them, and I perhaps did not include that. I don't see it in the table. Yes, I think I did not include that. It was an omission, but would you have that included? Well, it makes sense. It's logical to include them. All right, thank you, understood. Okay, but given the idea that I've stated earlier, it makes sense to include them. Chairman Lehman has a question to you. Thank you.
Yes, Mr. Varzar, I'll give you a moment to put your headphones on. This process is designed to help clarify doubts that we've told you we have. And yet you seem actually very confused about...
Just a moment, our subjects did not have the translation. Okay? Есть acum?
Da.
Okay.
Thank you, Mr. Varzar. This process is designed to clarify doubts that the Commission has, not doubts that you have. You seem very, very confused about your own financial situation, and that isn't really clarifying our doubts and ultimately not working to your benefit. But I want to specifically ask you about these 4 business trips. You went 3 times in 2019 to the Council of Europe, once to the European Union for a program in Finland. Presumably these were reimbursed in some portion or fashion. You want a very precise number to be added into the income column for what was reimbursed, and yet you yourself seem to be very unclear about what was reimbursed, when it was reimbursed, how it was reimbursed, and have no records from the Council of Europe or the European Union supporting that. Looking back at your answers, there were checks given to you as reimbursement by the Council of Europe. Do you have any records of those checks? Where did you cash those checks? Oftentimes, the amount that you spent is not necessarily the amount that will be reimbursed by the organization sponsoring the travel. There are, strict limits on per diems, and especially when you're driving rather than flying, it's a formulaic reimbursement. So we need something much more specific here than what you're giving us.
Deci, domnul Lehmann, eu am prezentat pentru 2019.
Mr. Lehmann, I submitted for 2019. I provided all the information from the Council of Europe regarding the amounts that were reimbursed by the Council of Europe on the occasion of those 4 trips altogether. That has been annexed to the materials of the case. There's only that one trip to Finland. That one trip to Finland.
Or 4 trips to the Council of Europe? Because we've heard 2 different numbers.
4.
There were 4. 4 from the Council of Europe and 1 to Finland. 5 altogether.
Okay.
And this is not about, well, it's, we're speaking of the inflow of money, not income and expenses. So that's why I don't say, oh, well, how much I spent on the trip or how much I received. I'm speaking of expenses that were covered by card, but were reimbursed to me in cash.
Both of those numbers are relevant. How much you spent and how much you received, both of those numbers are highly relevant to the financial evaluation calculations. So I challenge your perception on that.
So as for how much I spent on the trip, well, that was for the transportation, for accommodation, and the per diems for that trip, for the trip. It's only that at that time, when the trip has occurred, at that time I did not put down every transaction, did not keep record of every transaction to be able now to say what is the exact amount that I spent on that trip. What I paid for by card, that is available. And if there's anything that I spent, that I paid for by cash, well, I don't have the data for that. Everything that was reimbursed, that was paid back by the Council of Europe, that was sufficient, that was enough to cover those trip expenses. And now, thinking back of the formula that was accepted for 2019, to just analyze the cash flow, the incoming, the cash flow, the outgoing cash flow. So I am trying to think of some clarifications related to connecting some expenses to, or rather the omission to include some cash flows as a result of having covered them by card, with funds from the bank account. I mean, it's this that I'm thinking of. Right now, I am not speaking of amounts that I have fully received as a compensation from the Council of Europe. If I received 1,600 euros for a trip, for instance, and that is confirmed by the evidence in the materials, I mean, those were their receipts from the Council of Europe. So the 400 euros for the air tickets that was paid for by card, and the accommodation paid for by card, again 400, that should be shown as cash inflow in the amount of 800 euros, because I have covered that with money from my bank account. I paid for that by card, but it came back into my household, so to speak, by the cash that was given to me. And then I used that for my needs. So taking it out of that calculation is not justified.
All right, thank you.
Vă mulțumesc. O întrebare de concretizare.
Another clarification question to try to wrap up the discussion regarding this
Am vrut să
2019
spun
table.
că
The
suma
one thing that I wanted to add is that the amount,
cheltuielilor de vacanță
well, the vacation
efectuate cu
expenses,
cardul
the one that I
sunt iarăși în
covered by
acest
card,
fișier Excel și
they are
cumulativ ele
in the
însumează
Excel file,
34.600
and
lei, că n-am dus
together
în
that's
calcul de
34,600 lei. So out of the 55,000 or whatever was that amount,
inițial, da?
whatever
Este în
was there
tabelul din
initially,
runda a patra,
in
dar
the
aici undeva
table
în
in the fourth
paragraful
round,
corespunzător se
there was
menționează
something written there in one of the paragraphs.
urmează a fi deduse nu 20
So it's not the 21,000 amount, I don't remember how much you said,
but
but 34,600, the equivalent of that is to be deducted.
Lista acelor rulaje
There's the
din
list
vacanță
of
este în acel
funds
fișier,
related to the
deci
vacation. It's in that
deja
file,
se poate identifica.
so that can be singled out. Now, for clarification and accuracy, according to your calculations, the total cash inflow that you had. Now, what you used for your own calculations, what is that amount? What is it?
Deci, eu aici am analizat în calculul meu
In my calculations,
aspecte
I've
legate
analyzed
de deplasări,
issues
de
related to trips,
vacanță
vacations,
și cheltuieli rambursate de rude, da?
and expenses
Pe
reimbursed
poziția de
by
intrare,
family. So the
aici nu am
incoming flows. In this
intervenit
regard,
pe economiile numerar
I made no
formula
changes
care
in terms
am
of
vorbit
cash
anterior.
savings, I mean the
Am
formula that
omis,
we've already
probabil,
talked
din
about, and I think
gradă
I've,
sau
out of haste, I might have omitted
și
some
economiile
pieces
de
of
la
information.
sfârșitul
Then there are
anului, deci au
savings
rămas
at the
așa
end of
cum
the
au
year.
fost
They remain
reflectate
the
inițial.
way they were initially
Și
put
pe
down.
poziția de
And as
vorbind de
regards,
intrare,
so
am
speaking
primit
of the
suma de
incoming flows,
1.143.221
1,140,221 lei. 1 million, did you say? Yes. And the outgoing amount, it is subtracting that amount that you were mentioning, yes.
deducem
If we subtract the amount, the vacations, the 34,600 that I said, if we make that adjustment, we'd have 1,152,571. But to add, we should add the rent amounts still.
am inclus-o,
Because in the next year,
dar aici am
coming after that, I've included it. But
dar recunosc, da, trebuie
it is
să
an omission that I didn't do it for this year. So if we subtract that rent, or if we take out the rent amount, what is the balance that you ended up with? The balance, if we take that amount away, that's a minus 9,341 lei. Thank you. Let me see if my colleagues have questions regarding this table. If none, we can move on to the last table from this set of doubts. That is incoming flows, outgoing flows of your household for 2020. Total income, 2,059,102 lei. Total expenses, 2,097,834 lei. Negative balance, 38,732 lei. So the same formula, you can go ahead with the explanations.
Da, deci
Yes.
Doar pentru corectitudine e aceeași speță,
For
n-au fost incluse
Correctness. The
cheltuielile
same
de
case, we
chirii
did
pentru
not
anul
include the
2020.
rental
Dacă
expenses for the year 2020.
sau nu,
If you insist on that or not.
nu, eu le-am inclus aici.
No,
le-am
I
inclus,
included them
următorul
here.
am
I said that
inclus.
for the next year I
Da,
included
eu le-am
them.
inclus,
I included
51.700
them,
aici în tabel
51,700.
sunt.
They're here in the table.
Aici am făcut aceeași formulă la economiile în numerar. la
Made the
început de
same
an, sfârșit de
formula
an.
for the cash savings at the beginning of the year and end of the year.
Și atunci ar fi o diferență de
And that makes a difference.
deci în legătură cu faptul că fluxul numerarului în valută
So
s-a
in relation to the
diminuat,
fact that
desfășurarea
the
comparativă
foreign currency cash flow decreased at the end of the year
începutul anului, acea
compared to the
diferență
beginning of
am
the year,
inclus-o
that
doar
difference
la
was included
flux de
only
intrare.
as an incoming flow.
adică tabelul ajustat
meaning
în
the
formatul
adjusted
ăsta.
table in this format.
Asta la intrare. La ieșire
That's for
am
incoming
adăugat
flows.
valoarea
For outgoing,
acelor
I added the
cheltuieli
value of
de
those
locațiune.
rental expenses.
Și
And
referitor la numerar disponibil identificat
regarding
de
the
complet,
available cash found by the panel,
acele cheltuieli de locațiune fiind
those
suportate
rental
dintr-acel
expenses being incurred from
numerar
the
disponibil, deci cu suma
disposable
respectivă
cash.
s-ar micșora
That's the amount
numerarul disponibil identificat. Da? Adică
of
matematic nu ar veni, doar
to be
că s-ar-
subtracted from the
ar
available
veni
or
pe poziții
disposable
diferite, da,
cash.
cumva.
It comes on
O
different
poziție
positions.
diminuează și alta
One
apare
position
cu
gets
valoarea aceea care
lower
diminuează.
and the other is increased by
Și atunci 2020, da? Și aici o
so it's
poziție,
2020, and one position
poziție,
here
urmează a fi exclusă
has to be excluded.
legată de beneficierea efectivă.
That
da, am
is
propus,
related
excluderea
to
sumei de
beneficial
106.000.
ownership. I suggest to exclude the amount of 106,000.
Da.
That's
Da,
payment
da.
according to the sale and
E
purchase
aceleași
agreement.
argumente care am
Yeah, it's the
discutat
same
în
arguments as before.
Prin prisma conceptului de beneficiar efectiv.
Well, yes, in relation to beneficial ownership.
Venitul total.
Then what would be your total income and total expenses and the balance, please, according to your estimates? Total income 1,528,140 lei, and expenses 1,500,000. A positive balance of
Vă mulțumesc. Dacă colegii au întrebări,
50,000. Sorry, well, colleagues, do you have questions about this?
reiterez că conform
Otherwise, I'd like to reiterate that according to the tables that were discussed by us today,
completul
the panel
a constatat
found
o diferență
a difference of
totală
difference of
negativă
a negative balance
pentru anii
for the years 2014, 15, 16, 17, 19 and 20 of 875,575 lei.
luând în considerație cele expuse dumneavoastră,
Taking into account what you mentioned, I have to ask you, do you accept it? Amount of course I do not.
Matematic vorbind,
Mathematically speaking, well, based on for the reasons you explained before, yes. Here for the year 2021,
erau niște calcule și
there was some calculation, and
în rezultatul revizuirii
as a result of
s-a transformat într-un sold pozitiv.
revisiting them, it turned into a
Doar
positive
că,
balance.
eu
However,
am remarcat, am expus acolo
found and I
mai în detaliu,
explained it in more details there.
dar ideea este că
The idea is, however,
în
that
rezultatul revizuirii,
as a
din,
result of
un sold negativ de minus 6.000
recalculation
de lei, s-ar
from a negative balance of
transforma într-un
6,000
sold,
lei, it turns into a
pozitiv
positive balance
de
of 24,042 lei. 24,042 lei.
Ultima întrebare.
And then the last question regarding this. Did you make any personal calculations
per perioada de evaluare,
for the entire evaluation
diferența
period,
pozitivă sau
the
negativă
positive or negative
între venituri
balance
și cheltuielile în
between income and expenses of your family? If you made any calculation, it's not mandatory, it's up to you. I did not make any calculations, but we're speaking about the years we discussed today. Yes, according to the criteria under the law 252, that there are two negative balances, the ones that I mentioned,
azi
minus 35,000 and minus 9,000,
probabil cu valoarea
with
locațiunii împreună.
together with the value of the rental.
Eu vă mulțumesc pentru
I'd like to thank you
răspunsurile
for your
destul de detaliate la toate
quite
întrebările adresate dumneavoastră.
detailed answers to the
Acum,
questions we
înainte de
asked
a
you.
reveni la
Now,
prima
before
întrebare,
going
ce
back
ține
to the
de
first question
dublul privind
about
beneficiarul efectiv a
beneficial
bunurilor
ownership
imobile din
of the
stat
real
AM,
estate in Street Am,
propun o pauză
I suggest that we take a 5 minutes
Dacă
break.
toată lumea agrează
If
să facem
everyone
o pauză
agrees,
de
let's
5
take a
minute
5
înainte
minutes
de o oră
break.
și jumătate de când se
It's been
termină
2 hours
și
and a
5
half
minute
since
break.
our
Doar că
Ca să discutăm mai
hearing started, so let's
21 am
just,
vrut,
I
pentru
wanted for
claritate.
2021 to make some
Pentru mine nu a fost
clarity.
clar, deși
It
soldul
wasn't clear for me,
pozitiv,
even
dar
though the
24.000,
balance is
dar,
positive,
s-a
24,000,
dedus,
but
valoarea unui mijloc de
the
transport suportat în
value of
numerar,
a
și atunci dacă din el
vehicle
erau
was
121.400
subtracted there, that
lei,
was sold and it was
atunci dintr-un sold
21,400
negativ de
lei, and
minus
went from a
6.000 de lei,
negative balance of
dacă am
minus
deduce
6,000. If we
această
subtract
valoare,
this value,
am fi primit un
we
sold
would
de plus
get a
115.000 de
plus
lei.
115,000 lei.
Deși adică pentru mine
Am
nu este
înțeles.
clar,
It's
dar
not clear for
dacă
me,
soldul oricum e pozitiv
but
și
the
nu
balance is
afectează.
positive anyway, and
Doar
it,
că
is,
să
it does
nu-
not
în
affect
interior
it,
să nu
but
apar,
just to make sure that subsequently, Mr.
revenire
Varzar,
la acest
Cu
subiect.
referire la
with
acest
respect
aspect
to
pe care l-ați menționat
that aspect you
dumneavoastră,
mentioned,
puteți să ne
you
prezentați
can
clarificările pe care
provide
le
the
considerați
explanation. I
necesare?
provided them.
Vorbesc de
Provide the
anul
ones you
2020
deem necessary. I'm speaking about the year
cu soldul
2021
care a fost
with the
inițial
balance that was
negativ,
initially negative and transformed into a
și
positive
respectivele
balance,
clarificări care vreți să
and
faceți
the
cu privire
respective
la
clarifications you want to
valoarea
provide about the value of a
Eu am
vehicle.
făcut-o deja,
I
eu doar am
already
vrut să atrag atenția
did
că
that. I just wanted to draw your attention to
Deci
it.
facem o pauză de 5
Let's take a 5 minutes break and we'll be back. It's 6:47 now. Let's be back.
72 minute. Continuăm după pauză audierea
So
procurorului.
we continue with our hearing of Prosecutor Eduard Varzar. Mr. Lebedinsky, you have the floor.
Stimate domnule procuror, acum revenim la
Esteemed Prosecutor,
primul discutat,
we will go back now to the first doubt we discussed about
privind beneficierii
the beneficial ownership
familiei dumneavoastră,
by you and your families regarding the apartment, parking lot, and non-residential
de aici avem un
space in Street M. So from this issue stems a number of clarification questions.
prima întrebare va fi
And the
legată
first
de
of them
acel contract
will be related to the investment contract regarding the apartment.
în anul 2000,
In
în anul 2011
2011,
a fost semnat contractul de investiții.
an investment contract was signed between your sister
Acestui proiect.
and the implementing party of that contract. Later on, in the same year,
Nici în 2 luni,
in less than 2 months,
sora dumneavoastră a
your
cesionat
sister
acest contract de investiții către părinții dumneavoastră.
considered that investment contract to your parents, and later on, you, together with your family, concluded several rental agreements with your parents starting in 2018 and, as I understand, to this day, because you continue to live in that apartment. At the same time, in name of your mother, by power of attorney, you signed the Final Acceptance Act related to the apartment. Do you confirm this information or not? Yes, the sequence of events that you described is true. Thank you. So here's the question. Who found and negotiated initially, well, who found this apartment and who negotiated the signing of this investment contract by your sister, or between your sister and the developer in 2011? I mean, in the initial investment contract. I mentioned it previously, and I attached, together with the objections to the current notice of doubts, I provided an explanation from my sister regarding certain aspects related to that contract. This real estate was taken over from a prosecutor who refused to conclude the contract with the economic operator, meaning he did not have a possibility to do so. And as a result of information that became known to me, I found out about it from my colleagues, and knowing about my sisters and parents' intentions, who were at the time living together, meaning that my sister was living with them and they had a joint household. I asked about the possibility to take over that apartment, for that apartment to be taken over by my sister. That prosecutor asked the economic operator and the committee that was handling the distribution of apartments, the way that someone else could take that apartment over and to give up for certain family reasons. He had some family reasons. I did not get too familiar with them. Maybe I actually shouldn't be talking about them. And after it was found out what the procedure would be, it was done based on a procedure of notifying the parties by the two people. They submitted certain notifications to the commission members and to the economic operator, and when it was time to conclude the contract, the time when the economic operator concluded contracts with several beneficiaries, having that notification with the data of another person, they invited my sister to the company, to the notary, I think, directly, and they concluded that contract. Sorry, for clarification, you insist on the fact that you had the acceptance of a committee from the Prosecutor General's office responsible for identifying candidates eligible for the program of collaboration between the Prosecutor General's office and the developer, according to the list of applicants who wanted to benefit of apartments at a lower price compared to the market price at that time. I am not, well, I don't know, I did not take part in somehow in the discussions with that committee, but I know that it was accepted back then to provide a notification from the people about their intentions, pre-contractual intentions, or something like that. No justifying documents left. I did not take part directly in this notification, but as the person asked around, they were asked for some acceptance or agreements, consent, and probably there was a simple written notification, and from what I remember, there were no strict provisions about procedure. That's why we asked for clarifications from that person about what could be an acceptable solution. At the moment of negotiation and possibly at the moment of signing that investment contract, was your sister working in the prosecution service? No. Thank you. How do you explain the fact that in the contract, investment contract signed by your sister with developer, there are clauses stating that this contract falls within the collaboration program between the General Prosecutor's Office and the developer for providing prosecutors with residential space at a favorable price. I don't have any explanation because I did not take part in negotiating or drafting that contract, not even at the moment when it was signed. I actually did not know about that because it wasn't, I did not have a contract, I was not responsible for it, and I did not take that aspect into account. They were... My sister went to the notary and she signed something there, but what she signed, how she signed, I don't know even if she read that contract in full or in part. I can't say. I can't say that. Okay, then I have a question. Your sister, before and during signing the contract, did she know in person the prosecutor who was eligible, designated by the committee of the Prosecutor General's Office? No, we did not know each other before that. But what about you? What was your relationship with that prosecutor? Well, I knew him. He comes from the same rayon as far as we knew, but we did not have any friendship relationship, so no, only collegial. But the negotiation or the communication that underpinned the investment contract and your sister conceding to the investment to your sister. I did not negotiate a lot. There was nothing to negotiate about, or not a lot to negotiate about. But I found out about that person's inability, and I only asked, telling them that my sister is interested to purchase an apartment, and if a procedure is available, I wanted them to find out what the procedure was and to tell them and what she should do. So you did not apply to become part of that list of prosecutors who benefited of that collaboration project between the prosecutor's office and the developers, given that you don't have your apartment. I applied previously in the first building and they refused me, but I had a decision. I was involved in an enforcement procedure as a creditor about a social guarantee that prosecutors had regarding provision of residential housing, and I hoped that court decision would be enforced. And at that time, I wasn't even married, and I did not have enough financial resources to commit to a real estate investment. Thank you. Next, do you know, is your sister, that time in 2011, did your sister have the necessary resources to, as you are saying, you're saying you did not have the necessary resources. Did your sister have an income that would allow her to fulfill her contractual duties under the investment contract? My sister had resources, well, she had available resources, and I will explain in more details to be understood. She explained in her statement the evolution of her financial state over a few years. She worked in the United States when she was a student in the years 2006 and 2007 in summertime in some student programs. She had financial resources from there, and evidence was attached enclosed to the objections to the notice of doubts, and the source was explained, and the value of the available resources was explained. The idea was that when she came back from the United States, 2006-2007, having a joint household with my parents, she put her financial resources in my parents' household because the parents had purchased in 2003, or they concluded an investment contract on behalf of my sister, but they were the ones to finance that construction, that investment. And the discussion between my parents and my sister was that she was putting her money into parents' family as a compensation for the investment that parents made into the real estate, in the real estate on Street E. During the period when they had the intention to invest in another real estate, as I discussed before, they agreed for her to sell to my parents the real estate in Street E because it had a smaller area. It worked for the parents who were living at that time in Orhei, but they had the intent to move to Chișinău, so for my sister to sell to their parents this older, smaller real estate, and using the money obtained from the parents in exchange for the apartment to reinvest that into a new apartment, to invest into this apartment in Street M? Yes, yes, the one that we call that way in this hearing. Thank you for the details, and it means that the first installment, first payment for the apartment in Street M was made by your sister from her resources. I mean, the payment that happened in 2011. I don't know for sure who made the payments because I did not take part in payments, in negotiations. Just that soon she explained. I don't know if I can go into details in a public hearing, but these investment plans coincided with a series of events related to her civil status, let me put it like that. She was asked to marry. They filed with the civil registration office, and she was supposed to get married soon. For those reasons, I mean her and her future husband, they revisited her plans, and well, they changed, let's say, they changed their plans for the future. At the same time, my parents had available funds, and they decided to take over that investment or those investment obligations to take them over from my sister. And they had a concession agreement among them, and my sister conceded it to the parents. So they did not know how their plans were going to evolve, how the things would be. The future husband had agreements, contracts signed with various banks. They did not want to, so he had some credits, and they did not want to commit to an investment at a risk for them related to credits or enforcement potentially later. And since my parents had enough funds, they took over the obligations stemming from the initial contract, and they probably paid even the first and the subsequent installments. And we'll probably discuss it later on about my parents' financial capacity. Yes, we'll go back to that question. This was only about your sister, and now one more clarification question here.
Considering that you provided quite a thorough account of the context, and thank you for that openness. As the sister came back from abroad, she integrated her financial flows into the total flow jointly with your parents. And later on, after the sales and purchase agreement for that asset on the High Street, it is understood that it is not free of charge, but for consideration, it's a sales and purchase agreement. So that implies that the amount put down in that agreement, in that contract, that was given by your parents to your sister. Is that correct? Yes. Thank you. Let's move on. In 2014, your parents have written a power of attorney in your name, and on the basis of that, you signed the report on that, the takeover report, handover report for that apartment. And there were several powers of representation of parents in different statal and non-statal governmental and governmental bodies, such as telecommunication companies, electricity suppliers, and other utilities. So how can you explain as to, well, why did that happen? What was the reasoning for that? Why didn't the parents sign all the documents, given that it is their property? The reasoning for that was that, well, when we were with a notary, the notary can make adjustments to a power of attorney once this is desired, when one wants several several activities or several aspects to be undertaken. I mean, there are some forms that can be used and make the required adjustments if you want more to be covered by that power of attorney, I mean. And I think that was the case in this particular situation, too. That power of attorney was drafted, and we've had it because from 2008 onwards, my father has been working as a long-haul driver. So that what he used to work to. That used to be his job from 2008 until for many years. And often he would leave the country, and then he would be back for a short while, and then he'd be away again. And my mother would sometimes be in Orhei, in the house they had there, an apartment. They had an apartment there. And they didn't always have the possibility to be present. They weren't always available, and they weren't always able to take action when their action was required. And that is the reason for such a power of attorney. And it was in my name because I have legal education, and I can represent them In different instances, for instance, something that has to do with the legal field, that's closer to what I do compared to what my sister does. And I became a professional in law thanks to them. So it was their investment into their children. And there was also a moral obligation. I had a moral obligation to be there for them, well, not to reject their offer to have the power of attorney drafted. Thank you. If we are to take into account all the entire scope of powers bestowed upon you and what your parents did, their occupations, would you agree to say that you took care of signing of the handover report for that apartment and then being connected with all of the utilities, I mean, signing the contracts for that with the utilities suppliers and registering with the government everything that has to be registered regarding that apartment, so making sure that all of that paperwork is taken care of? Well, I can't remember very well the events that I can't remember very well instances where I would have taken some action regarding that particular real estate for them in their name. The signature on that handover takeover document, the signature is there, so I am not denying it. Well, there were perhaps some actions or something that was being done by the company in a centralized fashion with several contractors at once, and perhaps they were able to announce or to perform such a campaign so that all of those who have contracts to sign a set of required documents to progress things at different stages. And given that my father was abroad and my mother could have been in Orhei away, or maybe she wouldn't be able to comprehend what a particular matter was about. So they would allow me, or they would ask me to go down there and put my signature. The signature in the handover takeover document is there. I've seen it. I do not deny it. But otherwise, I can't remember other significant actions that I would have engaged in on their behalf. Considering what you shared with us, that your parents took over from your sister, that real estate on the High Street, that was an investment for them to have a place to move to in the capital city. What is the reasoning to invest shortly after in a property on M Street? I mean, that assignment where your sister was involved. How would you explain the economic or personal reasoning of your parents? Their intention was to make an investment into the future, given their retirement age, thinking of that. So in 2011, when they took that commitment, there were several circumstances that led up to that. And they had funds available in 2011. And throughout 2012, 13, 14, 15, and well, my father has been working actively throughout those years. And since they had the funds, they decided to rather invest that and then just to have a profit out of that. Thank you. Now, in the same train of thought, given the specificity of the work of your parent that implied frequent long-term travels away from home, who was taking care of the indoor works and the furnishing of that apartment? Since it was built and until you moved over there, I think some investments were made into some renovations in order to make it look proper and comfortable to be lived in. So physically speaking, I mean, who did that? Well, how would you communicate? How would you talk to the people qualified to do that? Connection with the utilities suppliers, and the procurement, provision of other services are required for the indoor works for the department. So could you provide some information on that? The indoor works that was carried out in 2016, well, until 2018, from the moment it was bought and onwards. So the first years, there were just payments being made. That's all. They didn't need to be in touch with the company doing the works there. We mean after 2014 when the takeover handover document was signed. So 2014, 2018, this is the 4-year period that we're interested in. So that handover takeover document, that was 2016. All right, 2016. Technical typo. So 2016, 2018, speaking of that period, who took care of all of those activities? In 2016, no indoor works were performed. That happened in 2017. They hired a person, and I provided the statement of that, a person from Orhei, an acquaintance of theirs. And for a particular X amount they've agreed upon, that is written in those documents. So they've agreed that that person would perform a range of works. And those works were meant to make the apartment comfortable to be moved into, but it was not supposed to be costly works. What about construction materials? Were they part of the contract? Yes. And that person took care of everything required for that. So my question is now, given the fact that you and your parents are closest of kin, what was the reasoning for those rental agreements from 2018 to this day? Because the vast majority rely upon some loan for use or usufruct contracts. Why was it a rental agreement between you and your parents? That is because before 2018, I was also renting. And likewise, expenses were incurred for that. For my parents, that was an investment. An investment into their future. It was a way for them to secure additional income. And for that reason, we've agreed that we would do that when we had to move due to certain circumstances, because the previous place where we were staying became unavailable. We couldn't stay there anymore, and thus we had the possibility, or rather the need, to move elsewhere, to rent elsewhere. So we had an option to rent from a stranger or to rent from your parents, and for particular reasons, thinking of the reasoning behind that investment altogether, and either way they were going to rent, we were going to rent a space. So that was, in a way, a contribution to provide the funds they needed, given their advanced age. I mean, you help your parents in any other way that is available to you. So they could have taken the money from a stranger or from someone who is their relative, but that does not change the essence of the legal relations in terms of that rent. Well, nobody is questioning establishing such relationships, including with parents, but we wanted to look into the reasoning into all of the explanations surrounding this apartment. Why wasn't the same reasoning applied by you in relation to the non-residential space and the parking lot? Officially, they are also properties of your parents, but are in fact being used by your family. Why weren't there contracts entered into for the use of those areas? Well, there is a loan for use signed for that. You mean gratuitously? That's right. So I was going to ask, why is it a contract for consideration that is for the apartment, but when it comes to the non-residential space and the parking lot, that is a loan for use, a gratuitous loan for use agreement? Well, they thought that the rental was enough of the apartment, that amount was enough for them, they thought, as getting money back for the investments they've made. In 2017, you, on behalf of your mother, signed a contract of investments into a non-residential space on that same street. However, you were not empowered in that regard. And then in 2019, on behalf of your mother, you signed a handover document with regards to that non-residential space on M Street, and there was no official power of attorney for you to do that. How can you explain that? It is your signature on documents that you yourself submitted. It's something that you scanned. That is correct, and I've provided explanations, and I've also provided documents from that company. In 2017, so that contract under power of attorney, that was just about formalizing, legalizing, so to speak, the intention of the buyer, that is my father. So that intention dating back to 2016, in fact. And my parents have recently shared with me some copies of documents. There is a receipt that confirms that in April 2016, he personally has given the company the value of that non-residential asset. But we're speaking of your signature on an official document on behalf of a different person. There is no contract, nothing empowering you to do so. Well, he made the payment in 2016. He made the payment. And that was for that non-residential asset. The availability of that asset was talked about with the company. There was a contract, and there was a clause, a term in the contract that the beneficiary could purchase a storage space as well. I understand. I am not questioning the right to purchase. Nobody's questioning the capacity. The question is only one. And in the 2014 power of attorney, that power of attorney stated that one can be represented to exercise all the rights coming out of the base contract. And the number of the contract is stipulated. But this is a separate contract, a separate investment contract. It has its own number, and that does not reflect any link with the 2014 contract. Without any remark as to your right, well, it doesn't mention that you have the right to represent your mother, for instance, in this case. Yet there is your signature. We're looking at this through the lens of the legal framework. Two official documents were signed, sales and purchase agreement and the handover takeover document for that particular asset on M Street. And those signatures, without having a power of attorney for that, legally not being allowed to do that. No power of attorney, no other type of empowerment, nothing that would have allowed you to do that. This is what our question is about. How was that even possible?
deoarece suma a fost introdusă în avans
because the payment was made in advance
înainte de
a few months before that contract was signed. And my father engaged into negotiations with the company as to when the contract would be drafted and signed. So periodically, when he'd come to Moldova, he'd go and talk it out with the company. And then they would say, soon, soon, and we'll let you know. And when they called him to show up for signing the contract, that power of attorney was presented, which in fact, perhaps, they had it perhaps from 2016, when the building was officially declared habitable. So there was that power of attorney, that nobody raised any issue, and I treated that power of attorney as one that gives you the possibility to act, allows you to act, because it contained provisions regarding all contracts that are related to the base contract and representation in relation to all the other assets. And given that my father had already paid for that asset, and given that my father had already performed the payment, he had the right to claim it because he had made the payment back in 2016. So that asset that the payment was made for, I might be misunderstanding things, so I'd like to go over this again. You, as a prosecutor, how would you rate this if there is a person who does not have any, is not empowered in any way, signs a document on behalf of a different person? But I was empowered by the power of attorney. That was for the contract for the apartment. But now we're speaking of a different contract for the procurement of a real estate of 7.3 square meters. Well, that was that contract and any other asset. That's what it was covering. Well, that is position, and you have no other explanation. Is that correct? I have no other explanation because the company called and they said, come over, let the person come over. If he's not there, then the representative can come who has a power of attorney. And given that the asset had already been paid for, and that was deemed to be an asset over which one has rights to claim as belonging to them. And well, given that situation, the developer, the company, had no objection as to what occurred, as if that was an emergency, you mean. And in 2019, on behalf of your mother, again, you've signed this handover takeover document for the non-residential space in 2019. Do you have the same arguments for that? No. Well, that document was not from 2019, and I've provided the explanation for the company that a document is from that date and that month, but 2020. But we have the scanned document. That's right. But some questions were raised during the rounds, and I've provided explanations. The year is actually 2020, and I've provided the explanations of the company, or well, if it's not an explanation, it's some piece of information. And I would like to explain that in that document, there is, well, it says in the document that so something in the body of the power of attorney before it was printed out, that I am taking action on the basis of power of attorney number X, I can't remember. So that power of attorney that is mentioned in this handover takeover document, that was dated the 30th of January 2020. So the company couldn't have had a document on February 2019 and make reference to a power of attorney dated the 30th of January 2020. So the handwritten mention, the handwritten date of February 2019 and the handover document, it was written by hand, so that is a mistake made by one of the employees of the company. They, instead of writing 2020, sorry, they wrote 2019. They've written 2019. So it was a mistake. The company confirmed it, because shortly after, they submitted the documentation for registration at the end of February. So the company confirmed this information that I just shared with you, and I provided evidence of that to you. Which is why I believe that the actions that were undertaken, well, that was under the power of attorney dated January 30th, 2020. Thank you. How can you explain that the document where you represent your mother for the parking plot, specifically for that investment, in the contract, they make a reference to that 2020 procurement that allows you to put your signature. But in the investment, in the investment contract and in the handover takeover document for the non-residential space, over there is no reference to a document that would allow you to put your signature on those documents on behalf of your mother. I did not understand the question. There is the 2020 investment contract, and there is the signature that you put on behalf of your mother on that garage investment contract. It says that your mother represented by you on the basis of power of attorney, right? And then your handwritten signature on the contract. So there is a mention in the contract that you have the right to represent your mother. That's what it says, and that you are legally taking action on behalf of her. Well, that is a contract that was drafted at the notaries. But then what is the difference? These are official documents. The investment contract has a legal form. So every signature put by a third party on behalf of a subject of a party to the contract, that has to be specified somewhere to make sure that the action taken is legal if you do that on behalf of a different person. So I wanted to know, what is your explanation as to that? Is it that... Well, I have no explanation, because when you go to the notary has a template, and they have their own way of doing things, and they process the contract the way they see fit. And the developers, they have their own templates, and then they fill them out the way they see fit. Thank you. Any questions regarding this from colleagues? I'm looking at my colleagues. Christopher?
No.
Let us then move on to the last part regarding this matter. Still, though, beneficial ownership. There is a decision of the Supreme Court of Justice from 2025, specifically with regards to what you mentioned today during the hearing, that you've filed a request with the local public administration authority in order to be given housing as per the law on the prosecution system back then. And following a number of litigations, you've taken the case to court, and in time, it lasted from 2006, when it was initiated, through 2025. There was a Supreme Court of Justice decision issued in July 2025. So, in support of your action, and specifically given how you were arguing, reasoning the fact that the failure to enforce in due time, I mean, the fact that you were not given housing in due time, that caused moral damages to you. And you've also mentioned the rent that you had to pay, including rent under the agreements with your parents. and the price would increase from 4,500 to 4,700, and then 5,000, all the way up to a bit more than 6,000. So what was the reasoning of the rising prices from one contract to another? And there was always an increase in the amount, in the rental amount. And the price was being adjusted in ways to reflect the market situation. And either way, the price was always somewhat, well, every time it was under the average, the market average. Thank you. Still in the same train of thought, if I may read out loud from that decision, it says that before 2020, before the 2020 contract, one more child appeared in your family. And thus the question is, taking into account that you are in direct relationship, kinship, and the birth of a child, wanted or not, is going to bring about some impact on a young family. So still shortly after, a new contract was entered into with a bigger amount for rent to be paid. So we'd like to make sense of the logic behind it.
I'm going to explain. The contract and the price are adjusted not exclusively or based on the tenant's ability to pay. The landlord, following market trends, wants to get a benefit that is more aligned with the market situation, but the financial situation at that time allowed to make bigger expenses for the rental, because at that time and in the years to come, we also received an allowance for child support, and it did not affect significantly the finances of my family. Thank you for your answer. And the finding that you have rather formal relations with your parents, in this case related to the rental. Our doubt was also formed as a result of reading this conclusion, that the arguments regarding the material, the financial damage you incurred as a result of state authorities, we mean the local authority and the bailiff, failing to enforce the writ of enforcement for providing housing for you and your family. Would it be wrong for the Commission to presume that these contracts, always growing in price, were only a line of attack, no, a line of action, let's say, I'm withdrawing my word attack. It was a line of action in court to motivate your position and the damages you suffered as a result of authorities and the bailiff's failure to fulfill their duties. Not at all. As during that court proceedings, this aspect was discussed, the relationship, the kinship between us. During the investigation, the local authority claimed that, and this was a fact that was discussed, and moreover, at a moment when it was decided to accept a legal relationship of a rental with my parents, I analyzed the case law, including ECHR case law, and there is the case Botezato versus Moldova, where at national level
zic eu, beneficiarul
the beneficiary
sau creditorul
or
într-o
the
procedură de
creditor
executare
in a
similară
similar enforcement procedure
i-a fost respins încasarea prejudiciului material
got a rejection of collecting on the financial damage because he
și în hotărârea Curții
was
Europene
a relative
agentul
to the
guvernamental a
person he was renting from,
și curtea în pofida
and at the ECHR, the governmental agent argued that, and despite that, the ECHR rejected it and accepted for that creditor to get the damages regardless of their kinship. That decision was passed in 2015,
dacă ar fi fost,
and
cum ați spus, o acțiune cumva
if it were
ea putea fi realizată
an action of sorts, this could have been done much earlier than 2018 if the real purpose would be different than what was stated in the court decision.
adică relații de locațiuni cu
The
persoane străine
rental
au fost
with
atât timp
other
cât fost
persons, strangers, were,
disponibili la acea adresă,
well, they
la acel
existed as
imobil.
long as they were available at that address in that real estate.
Ulterior,
And after
deja,
that,
un alt argument
another
căruia,
argument based on which
am acceptat
I accepted
această locațiune
this
din motiv că
rental was
cele două adrese a
that the
părinților și a acestui
two
imobil sunt în
addresses, my
apropiere
parents and this
și,
real estate, are close to each
pentru a
other.
fi mai
And
aproape
to
de
be
părinți,
closer to my parents
necesitatea acordării unui sprijin
and,
sau
well,
ajutor,
help them if
lor,
needed,
deoarece
because
careva din ei mai au probleme de sănătate,
some of them
mai
have
sunt
health
alte
issues,
situații în care
some other
apar
things
alte
happen
necesități de a
when
te
it
deplasa
may
repede
become
la ei
necessary to
sau
go quickly to them,
a lăsa copiii, de
or,
exemplu,
for instance, to leave the children with them.
și atunci o poziționare
And in such a situation, a favorable location counts in
favorabil unei decizii.
when you make a decision of this kind.
Vă mulțumesc.
Thank you.
Am încă două întrebări. În procura de
Two more
desemnată de părinții
questions. In the
dumneavoastră,
power of
prin care
attorney
vă
signed by your
amplificăți
parents,
mai
where they
multe aspecte imobiliare,
authorize you for several real estate aspects.
este așa o frază.
There's a sentence in it that states,
Citez. Să
and I
vândă
quote,
cuiva credit de cuviință orice
to
bun imobil
sell to
ce
whom
ne
he
aparține
deems
cu drept de
necessary
proprietate.
any real estate that belongs to us,
În
that
acest
we
scop,
own.
mandatarul nostru va face
To this end,
dovada calității noastre de proprietar oriunde va fi
he can prove
necesar, se va prezenta
us
discuțiile publice,
being
etc.
owners wherever necessary. He can represent us in before public
De
institutions.
corect ar fi
So how
dubiu că această procură va
correct
avea
would
dreptul
be that this
deja
power of
să
attorney
dispuneți asupra bunurilor
gives
imobile
you the
de
right to
proprietate a părinților
dispose
dumneavoastră,
of real
deja
estate
nu ca drept de
that your
folosință,
parents
dar
own, not only
ca
as the right of
drept de
use, but
proprietate,
also the
deoarece
right of
vă dă
ownership,
dreptul
because it
nu numai de a le
gives you
folosi,
not
dar
only
și
the
de
right to
a
use them, but
le
also
vinde
to
cum
sell
doriți
them
și
to
fără
whoever you
coordonarea
want without
până și după cui.
coordinating with them before or after.
Deci, iarăși reiterez, eu procur
I reiterate, it is a standard power of attorney which was drafted
notarul
by the
și
notary,
chiar nu
and
am avut niciodată intenție ca
have
să
never had the
dispun,
intent to dispose of,
și nici nu aș avea permisiunea
and I wouldn't have permission
părinților
of
să
my
dispună
parents
sau,
to
nu ar accepta ei
to dispose of them.
niciodată
They
ca
would
ei să
never
dispună
accept for me
fără
to
ei, deoarece sunt investițiile lor.
sell it without them. It's about their investment. I would never
Un astfel de
do, I would never try to do something to administer or to dispose of, because this is the right to dispose of something, to act in order to dispose of that property, to sell it, for instance, or to change it, or to set it as collateral or something. This is written in the power of attorney, but I don't believe that they would accept it, even though it's written in the power of attorney. And there are certain arguments for, these are the reasons why I asked for a closed meeting, closed hearing. But in a public hearing, I can't talk about that, because this relates to certain relationships among my family members. My parents, between my family, my parents' family, and my sister's family, and that's why I will stop here. I don't want to go into more details. I want it to be understood, and for this reason I asked for a closed hearing. Once it was decided that it is an open hearing, we'll have to stop here. And my last question, before giving the floor to my colleagues to ask questions, I would, in the context of this entire debate over this doubt, considering that regarding the real estate, the apartment, the garage, non-residential space, you acted on behalf of your parents, you signed the handover act, not having an authorization, meaning, for instance, the and if we look at it in combination with that lawsuit in order to get from the state real estate according to the law on prosecution, which I want to clarify. We as a commission, we do not challenge the right of every person to defend his or her rights, including to defend them in court. We do not doubt your rights, but looking at all of them together, and also the details from the last power of attorney issued by your parents, which actually gives you the right to sell and buy, that treats you as an owner. Isn't it a valid doubt that isn't it valid that it's you and your family who own the real estate, the garage, and but making it official cannot happen because it will damage your position in the court proceedings that you have been fighting since 2006 to 2025. So thank you, and your explanation is the only last thing we need here. I disagree with this argument. Beneficial ownership should not be viewed only in terms of the right of other people to represent someone. The holder of the right. The main criterion is the person who incurs or pays for the procurement and pays for the property and has the financial capacity to do so. My concern is that this aspect is not reflected in the notice of doubts, and I made references, and I have almost forgotten, but this got to be discussed, and I would like to reiterate one thing, that there are cases from other subjects of evaluation where there were also found cases of habitation with at the parents or parents-in-law, property purchase in own name, purchase of some auxiliary premises in their own name. That is one type of this is one type of relationship. I listed it in my comments, mentioning the specific case. Commitment in own name, but done from resources of other people, and concluding on in their own name without a power of attorney, transactions related to real estate, which were later explained during the evaluation that those were actually funds belonging to another person, that the subject concluded a contract in their own name because the person who the money belonged to was not in the country, and other similar cases happened in relation to rental of, I think it was about commercial premises, when people, and I wouldn't go into detail, it's not correct towards those people, but when you lead an entity, that entity benefited of rental from the manager of that entity. Information is available, open source about that. This was not treated as doubts. Going back to the person who makes the payment for the goods, who provides the money, I found there are 5 categories of cases, and I mentioned them. Where the evaluation found that the holders of the used property being subject of evaluation, but the property belonged to family members of theirs. Another category where the holders of the vehicles belong to actually family members, donations to subjects of evaluation or to their family members, lenders who provided loans to the subjects of evaluation or their family members. In another category, I mentioned where the alleged actual owners of certain assets, but the holders, the de facto holders, are the subjects of evaluation and their family members. So I provided examples of each of this category. The evaluation starts from the analysis of financial capacity of the person who, de jure and I believe de facto as well, made the purchase and proved the availability of financial resources that they used to make that purchase. And in this notice of doubt, I found findings that lead me to the idea, or that make me not understand why isn't it reflected, why isn't my parents' financial capacity analyzed, because somewhere it was written that they would have been unable to make this procurement.
concluzia nu este bazată pe
But the
calcul.
conclusion does not rely on a calculation.
Ori eu, neavând capacitatea de a face
Since
achiziții și având
I, being
părinții,
unable to make such a purchase and having my
azi
parents,
ignorăm faptul
why
că
do
ei
we
au putut să-și asume să
today
facă astfel de
ignore the fact
achiziții
that they were able and they could
și mi se
have
incriminează
make
mie
such
că eu le-am făcut.
a purchase, and it is incriminated to me that I did that. While looking at my parents' financial profile and looking at the development of their income and investments,
O evoluție, un circuit
you can see
care corespunde
a development, a circuit that is aligned to what I stated.
Taică-mi a realizat în ultimii 12
Because
ani
my father, over the last 12 years, working as a driver of a truck, earned around 96,000 euros
gradual în fiecare an
gradually
și
every year,
veniturile lui au
and
coincis
his
cu
income
investițiile care le-a
coincided
realizat,
with the investments they made.
că a lucrat
That
anterior
he had previously worked between 2008 to 2011, also as a long-haul driver, but
făcut dovada
I
documentelor confirmative a banilor incasați.
couldn't provide
Cum să o fac,
proof
dar am prezentat
for the
suficient
earnings because it wasn't possible for me to find confirmation documents, but I gathered evidence that proved that he worked
declarația fiscală
there.
care nu
The
s-a luat în calcul.
tax statement, tax return that was not taken into account because there are no certain documents that he had received that money. We are somehow applying
Extindem standardul perioadei
or
de
we
evaluare
expand the
o
standard
perioadă
of the
până la
evaluation
evaluare.
period over the period that was before the evaluation period, and we try to prove that there should have been documents,
Poate și trebuiau,
or maybe they should have, but they are not available today. But there's proof that for 4 years before 2012, he has also worked as a truck driver and he had enough financial resources to make these investments. And then, in the absence of a calculation of their financial capacity, a financial analysis of their income and expenses, with the conclusion that apparently they did not have enough financial resources, I think
incorectă,
this is incorrect.
lăsat așa într-o
And
parte, care
it is somehow
duce
put aside and
accentul pe alte
it
supoziții.
shifts the emphasis to other suppositions. Is that all? Thank you for your clarification, because this hearing is going to be public and will be accessible to the general public. Maybe not everyone knows what beneficial owner is.
Prisma este standardul internațional.
We have as a basis the international anti-money laundering standards that says for real estate that beneficial owner is the individual who exercise the ultimate control or who enjoys the benefits resulting from that real estate, even though in the official property documents another name is written, legal entity or natural persons. I'm giving this explanation so that people would understand, because we are discussing and you as a lawyer understand it and we understand this principle, but for the general public to understand why we discuss specifically from this point of view, because it was applicable both to the first part of the doubts and the second part. I have finished my questions here and I'd like to give the floor to my colleagues if they have any questions left. Christopher, do you have any more clarification questions?
No, I think at this point, I don't have any further questions.
Thank you, Mr. Varzar. I would like to make one remark only about what was mentioned by you. I assure you that the same rules and the same standards are applied in the evaluation of all subjects. Maybe there are some misunderstandings given the periods and some other aspects that are being evaluated or analyzed in the evaluation reports that you had access to, given their public nature. The Commission always applies the same rules. This is what you mentioned is your perception of things, and then given that we have no other clarification questions and everything was already asked, I assure you that the note you submitted and the additional materials that you provided as a result of the notice of hearing and the doubts, we will look into that. If you have additional data, we will accept you sending them to us by email, as all of our written communication with you was done before. And as we are approaching the end of this hearing, would you like to come with a closing statement? I would like to make a comment about what was said before. I did not want to say that the panel applies different standards. Not at all. I wanted to say that the notice of doubts does not include an analysis of my parents' financial capacity, because committing to those expenses that we mentioned today, the balance for the entire period of evaluation would stay positive, but not in terms of thousands, but not tens or hundreds or tens of thousands of euros after these investments are made. And I also provided the receipts, what they found, receipts that are confirming, well, there's not all of them, but what they found in their archive, receipts that confirm that they were the ones to make the investments. That was a receipt from the seller of a parking spot, a receipt on money for the auxiliary premises, and 2 receipts for paying the installments. And I think it would be right to take that into account and reflect these circumstances in the analysis. Otherwise, I understood, and I will do additionally what I said related to the EU delegation to provide proof of collecting the money in cash. And, well, I would just only like for all circumstances that I mentioned to be taken into account, and if there's still some unclarity left after processing what I submitted to you, I am open to clarify them. And, well, else I'd like to wish the best of luck to you and to the remaining subjects of evaluation. Thank you. Last comment. I don't want you to have the perception that something is incriminated to you. The Commission, during the evaluation of ethical and financial integrity, does not accuse the prosecutor or any other people of committing acts or inactions or failure to act related to financial aspects. We just try to elucidate all circumstances in order to be able to carry out a very impartial, fair, unbiased evaluation of every individual subject. Having said that, I would like to thank you for participating in today's hearing, in the entire evaluation process. It has been, and thank you for patience, because it has been quite a cumbersome process. We will analyze the materials that you have sent to the panel after the hearing notice, and if the panel needs to clarify some more aspects, we will send you an additional round of clarification questions. If no additional clarification is needed, but you still expressed your openness to provide, if any. if it is not necessary to ask additional question, we will issue a report as soon as possible within 30 working days that will be sent according to the procedure established in the law within 3 days from its approval to the subject of evaluation to the Superior Council of Prosecutors. Thank you, and I wish you the best of luck in your work. Having said that, the hearing of the subject prosecutor in the General Prosecutor's Office, Eduard Varzar, is declared closed.